Yes, Mr. Hodge.
Commissioner, the next witness is Ms Elkins from Colonial.
Yes. Ms. Elkins, would you come into the witness box, please? I should have looked up to see whether you'd prefer to be sworn or affirmed, but what's the answer?
Sworn, please.
Perhaps if you'd be good enough to swear the witness, please.
Please repeat after me. I swear by Almighty God
I swear by Almighty God
that the evidence I shall give
that the evidence I shall give
will be the truth,
will be the truth,
the whole truth,
the whole truth,
and nothing but the
and
truth.
nothing but the truth. Thank you.
Thank you very much. Do sit down. Yes, Mr. Finch.
Thank you, Commissioner. Ms Elkins, could you give the Commission your full name, please?
Linda Marie Elkins.
And I think your business address is ground floor, 201 Sussex Street, Sydney.
Yes.
And I think you're here today in answer to a summons dated 30 July 2018.
Yes.
Do you have a copy of that summons there with you? I don't know whether Commissioner, you have a convenient copy to hand. I tend to the summons.
Yes, Exhibit 5.178 will be the summons to Ms Elkins.
Thank you. And I understand that you've made a number of statements in connection with your appearance.
Yes.
And one of them is one dated 26th of July 2018 in connection with rubric 5-17.
Yes.
Another is dated the same day, 26th July 2018, in connection with rubric 5-18, in particular sections C to E.
Yes.
Another is dated the 30th of July 2018 in connection with rubric 5-37, sections A to H and questions 26 to 29.
Yes.
And the last is dated the 7th of August 2018 in connection with rubric 5-78.
Yes.
And are the contents of those statements true and correct?
Yes.
I don't know whether it's convenient, Commissioner, for me to tend to those sequentially.
I think sequentially is better, Mr. Finch. So if we say Exhibit 5.179 is the statement of 26 July 18 concerning rubric 5-17 and its exhibits, 5.180 the statement of 26 July 18 and its exhibits concerning 5-18 C to E, 5.181 the statement of 30 July 18 concerning 5-37 A to H, and 5.182 the statement of 7 August 18 concerning rubric 5-78.
Thank you, Commissioner. There's nothing further.
Yes. Thank you. Yes, Mr. Hodge.
Thank you, Commissioner. Ms Elkins, you're presently the Executive General Manager of the Colonial First State business.
Yes.
And you're also a Director of Colonial First State Investments Limited.
Yes.
And you're also a Director of, is it Avanteos or Avantos?
Yes, Avanteos.
Avanteos Investments Limited. And are each of those entities trustees of superannuation funds, or is it only Colonial?
They're both trustees of superannuation.
And I'm sorry, just because it's being recorded and also to help the Commissioner, you might just need to speak up a little bit,
Sorry.
Ms Elkins. Now, what I wanted to start with was to deal with an issue that arose in 2014 in relation to the transition or the requirement to pay new default contributions into a MySuper product.
Yes.
And you know, and we're aware at the time, that under the amendments that had been made to the legislation to introduce MySuper, there was a requirement that all new default contributions be paid into a MySuper product.
Yes.
And it was a strict liability offence not to do so.
Yes.
Now, in the lead up to 1 January 2014, APRA had written to all of the RSE licensees.
Yes.
And if we bring up RCD.0025.0009.004, this is the letter I think we're both talking about, a letter of the 15th of November 2013.
I don't.
You're not sure whether this is the letter you're thinking of?
I'm not sure if I accept that that's a letter probably sent. I imagine that was sent to all trustees.
Yes, it's addressed to all registrable
Oh, yes, okay.
superannuation entity
Yes, we would have
licensees.
received that.
And I'll just note a couple of things. You see in the third paragraph, APRA says, RSE licensees are reminded that from 1 January 2014, default contributions can only be paid into an authorised MySuper product. And an RSE licensee commits an offence under the SIS Act if it does not comply with its obligation in relation to the treatment of default contributions.
Yes,
And you see in the last paragraph, those RSE licensees that presently receive default contributions but have no intention of obtaining authorisation to offer a MySuper product are expected to be well advanced in the implementation of appropriate administrative arrangements to ensure that default contributions are not accepted into the fund from 1 January 2014.
yes,
Now, Colonial First State First Choice Superannuation Trust had a MySuper product that was in effect from 1 January 2014.
in the employer sponsored division it did, but not in the personal division.
The superannuation fund itself had a MySuper product.
We built a MySuper product at that time in the employer sponsored division of that trust.
And again, just so we can be clear about the distinctions being drawn here, there is one trust, which is the fund.
Yes, and then there's products.
There are products or
Yeah.
divisions within.
That's right. So the employer-sponsored division, we built a MySuper product in that division, but there wasn't one in the other divisions.
And a few months after I'm sorry, Commissioner, I tender that document.
Letter APRA to RSEs 15 November 13 RCD 0025 0009 0004 Exhibit 5.183.
And then a few months after 1 January 2014, Colonial First State gave notice of a breach to APRA.
Yes,
And can we bring that up? That's CBA.001.0451.0190. This is a breach notice you've looked at before
yes, I believe so.
in preparation for giving evidence. Would it help if perhaps if we go to the third page, which is .0192? You see there's a description at the bottom of the page of the breach.
Yes,
And you see at the top of the page an identification of the legislative provisions that had been breached.
yes,
And in this case, the breach was of 29, capital
Right.
W, capital A.
yes,
And the breach was that, in respect of, at that time, approximately 13,000 members of First Choice Personal Super, they had made a default contribution into the fund since 1 January 2014, and it had not been paid into the MySuper product.
that's right.
And the way in which members became members of the First Choice Personal Super product was typically one of two ways, as I think is explained in the breach notice. Either automatic transfer over from First Choice Employer Division,
Yes,
or alternatively, if there was a successor fund transfer from some other fund
that's right.
into this fund, then they would be moved into First Choice Personal Super.
That's right.
And in respect of, at that stage, what had been identified was 13,000 members, Colonial First State had no investment direction on
That's
file
right.
for them. And that meant that under legislation, any contributions they made were default contributions.
That's right.
And the breach occurred immediately, so from the 1st of January 2014.
Yes.
Do you know why it was said that the trustee only became aware of the breach on the 10th of March 2014?
Because my understanding, or remembering back to that time, was that we hadn't properly identified this group of members as being part of our ADA cohort. So an error on our part in recognising them.
Was the issue that Colonial First State
Yeah.
had suggested that the members had made a choice of fund and therefore that would constitute an investment direction?
For some of them, for those that had done that. So I think there was more than one thing at play. And again, I'm going on my memory of the time. I haven't gone back and refreshed the reasons for the lack of identification of them. But we built a retained... The moving the members, the transferring them into the personal division had ceased. That wasn't a practice we were doing anymore, and I think that contributed to not recognising them. When we did, we then saw within there people who had then chosen that fund, and we therefore did consider them to be choice members.
Do you know how it could be that a trustee as large and sophisticated as Colonial First State had not identified before the 1st of January 2014 which members were choice members and which members were default members?
I think just the complexity at the time.
And what does that mean exactly, the complexity at the time?
We were looking right across the business for, identifying the groups that would be in the ADA groups, and this got missed.
I see. Now, again, just so I can try to put this in some further context, I tender that document, Commissioner.
What's the date of the breach notice?
Oh, I'm sorry.
Mr. Hodge.
The date of the breach notice is the 19th of March 2014, Commissioner, if we bring up .0193.
Breach notice, Colonial First State investment to APRA, 19 March 14, CBA 0001 0451 0190, Exhibit 5.184.
You may not recall this, and to assist you, I'll bring up a document. If we bring up CBA.001.0451.0173, so this is a letter sent by Colonial First State. It's signed by Mr. Sutherland
Yes.
on the 6th of March 2014 to APRA. Does Mr. Sutherland report to you, or did he at the time?
No.
What
No, he
part
did-
of the business is he in?
He was the wealth management risk officer, so I would refer to him as my line 2 risk person. So that's a person who adds challenge and review to my business but doesn't report to me.
I see. And you see Mr. Sutherland refers to a meeting with an APRA liaison
Yes,
on the 21st of February 2014.
yes,
And you see he explains in the second paragraph, at that meeting you requested that we outline the circumstances relevant to, that's first choice personal super, and the reasons why Colonial First State Investments Limited is unable to meet the requirements of Section 29, capital W, capital A.
yes.
Again, you may just not be able to assist us, but you don't know why it is that it is said that the breach was first identified in March of 2014, if in fact it was being discussed with APRA on the 21st of February 2014.
Yeah, I must admit, I'm not sure of the specifics of the sequence of events there.
But I tender that document, Commissioner.
Letter Colonial First State to APRA 6 March 14, CBA 0001 0451 0173, Exhibit 5.185.
And the position that Colonial First State took was that it was not possible for it to transfer or to move these default contributions into a MySuper product.
At that time, yes.
And do you know why it was not possible?
Because we didn't have a MySuper product in that fund that we could move them to. And I think then there was also a range of systems issues or systems that would need to be built in order to transfer them elsewhere.
Well, there was a MySuper product within the fund, which was part of the employer division.
Yes, but you had to be employed by one of the employer groups to be in that fund.
Was that a requirement under the
Yes.
trustee?
Yes.
I see. And so then instead you needed to look for a different
Another.
MySuper product to move
Yes.
them to.
And go through the process of selecting that.
And what was the different MySuper product that you...
Eventually, the MySuper product was Essential Super. Commonwealth Essential Super was selected.
Sorry, Ms Elkins, you're dropping your voice. Could
Sorry.
you be good enough to keep it up?
Yes.
Thank you.
Could you just explain to the Commissioner what Commonwealth Essential Super is?
So Commonwealth Essential Super is, we refer to it as a simple superannuation product, MySuper product, that is was made available through Commonwealth Bank branches at the time.
And which fund was it part of?
It was a separate fund.
So there was a new fund that was established in order to house that product.
Yes.
And there was a distribution agreement in relation to that product
With the retail bank, yes.
with CBA.
Yes.
And as part of that, there was a revenue sharing arrangement.
Yes.
We'll come back to that. Just coming back to what's happened in March of 2014. So at this time, the position of Colonial First State is we haven't complied with the law,
Yes.
and it was known that the law was coming into effect since 2012.
Yes.
And it was said we're not going to establish a MySuper product within the Colonial First State trust that is capable of receiving these default contributions.
Yeah, that yes.
And so the options that were given to APRA were either we will implement a block on the receipt of these contributions, or we'll just have to keep receiving these contributions.
Until we do the transfer of the whole amounts.
That is, until you transfer the entire accrued default amounts
yes.
to a MySuper product.
Yes.
And what MySuper product were you going to transfer them to?
At that time, the decision of which MySuper product hadn't been made, but it was then decided it was going to be Essential Super.
So the legislation had been in place since, I think it was 2012, was that right?
Yes.
And it had been foreshadowed since 2011.
Yes, I think that's right.
And there were accrued default amounts that one way or the other were going to need to be moved into a MySuper product.
Yes.
And there was an obligation on the part of Colonial First State to move those accrued default amounts over as soon as it was practical to do so.
Yes.
But in any event, no later than the 1st of July 2017.
Yes.
And I'm just trying to understand how Colonial could have thought that it was complying with its obligation to move the ADAs over as soon as possible if by 1 January 2014 it hadn't even figured out what MySuper product it was going to move them to.
Well, that's because it hadn't recognised that group.
Oh, I see, it didn't know that there were ADAs
Well, we hadn't.
other than what was in the employer division.
Yes, I think that's right. I'm not sure actually the sequence of events there, but I think that's right.
Is a possible explanation for the approach of Colonial First State that it wished to maximise the period of time that the ADAs remained as ADAs?
No, I don't. That was never discussed.
The consequence of the ADAs being moved over to a MySuper product was that commissions would cease,
Yes.
and the ceasing of commissions to advisors was a matter of concern to Colonial First State?
It impacted advisors, yes, that worked with us.
It would reduce their revenue.
Yes.
And that was a factor that Colonial First State took into account in deciding when to transition ADAs over to the MySuper product?
We didn't ever discuss the commissions, but that is a consequence, yes.
I see. It was never something that was discussed. It was just a known consequence.
Yes.
Commissioner, have I tendered that document already? If not, I tender that document.
It's in as Exhibit
Thank you,
5185.
And if we then bring up CBA.0001.0451.0200, so this is a letter of the 19th of March 2014 to Ms McMahon of APRA.
Yes.
And I think if we go to page 2, we see you are the signatory
Yes, I am. Yep.
to that document.
Yes.
And if we go back to the first page, we see you are explaining that Colonial has considered a number of options to deal with the issue of these many offences, and the plan that it has come up with is to, and you describe it as, commenced a proactive outbound calls via the call centre to contact affected members to obtain and record a valid investment direction.
Yes.
And you express confidence on behalf of Colonial Management that you will achieve a high member response rate,
Yes.
subject to the plan being acceptable to APRA.
Yes.
I tender that document, Commissioner.
Letter Colonial First State to APRA, 19 March 14, CBA 0001-0451-0200, Exhibit 5.186.
APRA sought a copy of the call script from you.
Yes.
Can we bring up CBA.0001.0451.0203? So this is an email from Mr. Sutherland copied to you back to APRA.
Yes.
But you can see it's redacted, but yeah, I think you've looked at it before, and it goes to Katrina Ellis of APRA.
Yes.
And you see it says, please find attached the call-out script and proposed member communication. And then can we bring up CBA.001.0451.0204? So this is one of the attachments, which is the outbound script for contribution directions.
Yes.
And it seems like the information in the box is the instructions to the call centre operator.
I think
And
that
it-
probably, yep.
And then below it is the script.
Yes.
And so the instructions given to the call centre operator begins with, from 1 January 2014, legislation changed regarding investment directions for contributions. We must have on record a direction from each member as to how they would like their contributions invested.
Yes.
Is that statement true?
They're referring there to, in order for someone to be a choice, to be identified as a choice member.
Do you agree the statement as written is not true?
It's standing on its own. You're right.
If we take the elements of it, the statement is saying that there was a legislation changed regarding investment directions for contributions.
Yes,
That's somewhat accurate. There was new legislation that affected what happened if there was no investment direction.
yes,
And then it says we must have on record a direction from each member as to how they would like their contributions invested.
yes.
That's not a requirement of legislation.
No, that's a requirement in order for them to be a choice.
It's only, that's right. It's only, the only requirement under the legislation is if there is no investment direction, then new default contributions have to be paid into a MySuper product.
Yes,
And then you see in the script, after the general introductory words and the security check, that then what the call centre operator is instructed is to say, we have been receiving contributions into your account and they are currently being invested into the whatever investment option it is. You're able
Yes.
to pick that up in the middle of the page.
yes,
And then the call centre operator is to tell the customer there has been a recent change to legislation which requires us to confirm the investment options into which you would like your superannuation contributions paid.
yes.
And that statement, do you regard that as true?
I can see now what you're saying, that it's not.
Not true. Because it says,
It was standalone. No, it's not correct. It's not correct.
but it achieves the purpose that Colonial was setting out to achieve.
Colonial was wanting to, Colonial had a view that these were choice, that these people had made a choice, and was seeking to get the investment confirmation from them.
Well, they'd never made a choice as to investment options, had
Not
they?
to investment option, but to fund. That's right.
And when you say they'd made a choice as to fund,
Yes,
that's for some subcategory of the members.
that's right.
Where the employer has taken up the employee's nomination as to what is going to be the default fund.
The other way round, where they have taken to their next employer this fund as their choice.
I see. They've carried the fund over.
So when they've gone to their next employer, instead of accepting the default of that employer, they've said, no, I'd like this fund.
Yes. Do we agree that in no sense is choosing a fund the same thing as making a choice of investment product to invest in some specific investment option rather than the default product?
I agree with that. At the time, that was the source of our contention, I guess. But yes, that is correct.
But the contention by this point is done. You have given a notification of breach to APRA.
Yes, but we were still of the view, as we expressed to APRA, that these people, we wanted to confirm whether these people wanted the investment selection.
I'm not sure I understand that. You wanted to confirm with APRA whether they wanted the investment selection.
We had confirmed with APRA that we would be calling these people to confirm the investment selection.
Yes, I understand. You sent this script
Yes,
to APRA.
To APRA, yes.
And APRA didn't contact you and say, this is obviously misleading, don't do it.
Well, no.
An advantage to Colonial of using a script like this is that if it leads the member to make the investment choice, then you don't have to pay new contributions into a MySuper product.
They can stay where they are.
That's right.
Yes.
And again, just to be precise about this, in relation to new contributions, you don't have to pay them into the MySuper product.
That's right.
You cease to commit an offence.
Yes.
And is it because this script is misleading that Colonial was so confident that it would lead to members making an investment choice?
At the time, we were confident that the members wanted to stay in the fund, or their actions represented that. I do accept that this script should have been more balanced in the way it described that.
When you say more balanced, do you mean not misleading?
I mean, it should have described, it's treating just the investment selection in isolation of the broader MySuper transfer.
Do you
And it
accept
shouldn't
that?
have done that.
Do you accept that it's misleading?
Yes, I do.
I tender the email together with its attachment, Commissioner.
Email CBA to APRA 26 March 14, CBA 0001 0451 0203, and attached call script CBA 0001 0451 0204, Exhibit 5.187.
Now, if we then bring up CBA.0001.0451.0208, this is an email from Mr. Sutherland to you,
Yes?
and he's describing to you a conversation that he's had with Katrina Ellis of APRA.
Yes.
And you see, he says in the second point, APRA are conducting fairly extensive internal inquiries likely to be in regular contact in next 24 to 48 hours.
Yes.
And then you see the fourth bullet point down, APRA currently going through the scripting letter.
Yes.
And then you see the sixth bullet point down, two key questions at this stage which we should proactively develop a response to. How has the trustee satisfied itself around not getting a written direction from the members contacted over the phone?
Yes.
And that was because what Colonial was proposing to do was to talk the members that it called through the form over the phone,
Yes.
and that the call centre operator would complete the form herself or himself.
Yes.
I tender that document, Commissioner.
Email Sutherland to Elkins 26 March 14, CBA 0001 0451 0208, Exhibit 5.188.
And then if we bring up CBA.0001.0451.0217, this is an email from Mr. Sutherland to Ms. Ellis on the 4th of April 2014.
Yes.
You weren't copied to this email though, I don't think.
No.
And you see he says, please find attached and below final version of member communication letter that Colonial First State Investments Limited is mailing to affected members from next week, and latest member call-out statistics.
Yes.
And then if we then bring up on the other side of the screen, CBA.0001.0451.0218. So this is the template communication that was going to go to members.
Yes.
And you see in the second paragraph, it says there has been a recent change to superannuation legislation which requires us to hold an investment direction from you in relation to future contributions paid into first choice personal super.
Yes.
Now, do you agree that that statement is misleading?
That has the same problem as the script, yes.
And it then says, if a direction is not held by us, we are unable to accept contributions into your account.
Yes.
And that's true only in one very limited respect,
Yes.
which is you would have to put a block on receiving default contributions.
That's right.
Or at least that's what you were saying to APRA.
Yep.
Yes.
Sorry, yes.
And then the letter was going to say, for this reason, we would like to confirm the investment options into which you would like your contributions to be paid.
Yes.
And then you see at the bottom of the page, there is a heading which is what will happen if you do not reply.
Yes.
And it's explained that if no direction is received by 10 May 2014, we will commence the process to transfer your account into a MySuper product.
Yes.
Would that have been right? That if no direction had been received by 10 May 2014, you would have transferred it into a MySuper product?
I can't be sure how that date is relating to the actual process that was happening.
One respect in which I'm particularly trying to understand that is, as you know, under the legislation and regulations and I think prudential standard dealing with MySuper transition, it was necessary to give members 90 days notice before transferring their ADAs over into the MySuper product.
Yes.
And it was also necessary to provide them with a certain amount of detailed information so that they would understand what was happening.
Yes.
And that would include information, for example, about changes to fees and things like that.
Yes.
There may have been an exception, which was if it was going to be beneficial to them in any event to go over to the MySuper product, you may not have needed to provide fee information. I'll have that checked, but I'm assuming you're not sure about that.
Sure.
But in any event, this letter isn't a letter that complies with those legislative requirements. Do you agree?
Yes.
And it's then said about the process to transfer your account, the member's account into a MySuper product. This may result in costs to you and the loss of any insurance cover you may currently have in First Choice Personal Super.
Yes.
And can I suggest the obvious intent of that statement is to cause the member to be apprehensive about their account being moved over to the MySuper product?
We wanted them to turn their attention to the investment options and the insurance that they had.
Well, you didn't want them to understand it in the sense that you weren't providing them with information so that they could compare what the fees would be, whether there was still trailing commission, what the insurance would be. You weren't providing them with any of that information.
You're right, but our concern was to ensure they turn their attention to it, but I do accept that we didn't provide them with sufficient information.
Well, the concern was to have them, and if we go over the page to page .0220, the concern was just to get them to sign a simple contribution investment direction that would mean that nothing changed.
That was the action if they wanted to stay.
But you weren't providing them with any information to enable them to make any informed judgment about whether they should stay.
I agree we didn't provide them sufficient information. We should have.
The purpose of this letter was to assist Colonial to stop committing an offence.
That wasn't, our focus. Yes, we were focused, of course, on stopping the breach, but we had genuine concern for that these members would turn their mind to their investments and their insurance.
I just wonder, when you say that you had genuine concern about that, what the basis is for you saying that that was the reason that you did this.
Because we could see that the investments they held and the insurance they held would be very different if they were transferred.
There was no analysis done of how this would affect the members, that is changing from their current investment options over into the MySuper option.
The product managers had been doing that analysis, but I agree, we didn't share that with the members and we should have.
This was, as we've seen from the documents, a mail out and a letter that was the product of one thing, which was APRA saying you are committing an offence and Colonial needing to stop committing offences.
Yes, you're right.
I tender the email and the attachment, Commissioner.
Email Sutherland to APRA, is it Mr Hodge, I think?
Yes, Commissioner. That's
Email
correct.
Sutherland to APRA 4 April 14, CBA 0001 0451 0217, and attached template letter to members, CBA 001 0451 0218, Exhibit 5.189.
And then on the 29th of April 2014, APRA wrote back to you personally, and we'll bring that up. That's CBA.00001.0451.0241. So you see, this is the letter from APRA to you.
Yes,
And in the second paragraph, you see attachment A summarises the aspects of your plan to deal with the breach.
yes,
APRA's understanding is that under this plan, rectification for all affected members will be complete by early September 2014, as members will either have given investment direction indicating they wish to stay in first choice personal super, or they will have been moved to a MySuper product.
yes,
Subject to any matters that may arise from the information requests below, this plan is acceptable to APRA.
yes,
And if we just go over the page, over 2 pages to .0243. This is APRA's summary of the plan you've given them, and the first dot point is contacting all affected members by phone or letter during March to July 2014 in order to obtain a valid investment direction.
yes,
And APRA knew, because you provided it to them, what the contents of those communications were going to be,
yes.
and APRA raised no issue with them.
Not that I'm aware of. They were obviously talking with Peter Sutherland as well, but not to my knowledge.
Did it surprise you that APRA raised no issue about these communications?
No, not at the time, no. 'Cause, you know, I think it was a time when a lot was going on. And when I look at the communications now myself, I can see their shortcomings. But that was not apparent to us at the time.
Did it surprise you that APRA took no steps with respect to the already admitted 13,000 offences that Colonial had acknowledged?
I thought APRA was acting appropriately to ensure that we were resolving the breach.
I think one of the things you're acknowledging is that in hindsight you can see that the communications are misleading.
They could have been better, yes.
I think you have, you're walking it back now, I think, to go
No,
back
I'm
to
not
the...
trying to do that.
It's all
Mr.
right.
Hodge. Yeah.
Everybody does it. Everyone says they could have done something better rather than just saying we did something wrong. But
We did
you
something
have,
wrong.
you have, I know, you've acknowledged it, you've done something wrong. When you think back on that and the misleading nature of the communications, it would seem that both you and APRA want you to obtain these investment directions so that you cease breaching the law.
I can't comment on what APRA was thinking. No, I didn't think that at the time.
I tender the document, Commissioner.
Letter APRA to Elkins 29 April 14, CBA 0001 0451 0241, Exhibit 5.190.
Now then, as things go along, you provide regular, or Colonial First State provides regular updates to APRA.
Yes,
And we might just show an example of this if we go to cba.0001.0451.0426, so this is an email on the 29th of May 2015 from Mr. Clements,
Yes.
who is somebody employed with Colonial First State.
Yes, he would have reported to Peter Sutherland. I
And we
believe.
can see from the subject line, this is the 13th update in relation to Colonial First State's contravention of Section 29, capital W, capital A.
Yes.
And by this stage, you were dealing with the 5th tranche of members, and each tranche was a tranche comprised of members who had made default contributions within a particular period of time.
Yes, that's right.
And so the initial tranche were members who had made a default contribution between 1 January 2014 and 14 April 2014, or thereabouts.
I think that's right.
And then there was another tranche, we can see this on
Yep.
page 2.0427. Tranche 2, members who made a default contribution between 15 April 2014 and 24 June 2014.
Yes.
Tranche 3, 25 June to 31 October.
Yes.
Tranche 4, 1 November to 30 April 2015. You see that at the bottom of the page?
Yes. Sorry.
And tranche 5, 1 May, this is on the first page. 1 May and 31 October 2015.
Yes.
And then I tender that document, Commissioner.
Email 29 May 15, Clement of Colonial First State to APRA, re Section 29 WA, update number 13, CBA 0001 0451 0426, Exhibit 5.191.
And then if we go to cba.0001.0451.0889, so this is now an email sent on the 22nd of February 2016. You can see that, Ms. Elkins.
Yes.
And this is the 17th update in relation to the contravention of 29 capital W, capital A.
Yes.
And you're copied to that email.
Yes, I am.
And you can see there's then been a 6th tranche, and that's included members invested in a cash option.
Yes.
Can you recall what that was about?
I
Only what's
don't
written there.
recall. I don't really remember, but that looks like again that there was a identification issue.
An identification. There were some new members that
Yeah,
were
there were
found.
some new that were found
that
that
were
were part of
ADAs.
this. Yeah.
And then we can see at the bottom of the page what's described as the final tranche, which were for member contributions occurring after 1 November 2015.
Yes.
Attend to that document, Commissioner.
Email Colonial First State to APRA 22 February 16 concerning Section 29 WA, update number 17, CBA 0001 0451 0889, Exhibit 5.192.
And then in about mid-2016, do you recall that a new problem was identified, which was members with ADAs in first choice employer superannuation? I
Yeah.
can maybe help you. Can we bring up CBA.001.0451.1377?
Yes, that similarly there was yeah, that's right.
Sorry, what were the last four digits?
I'm sorry, it's .1377. So this is a letter on the 8th of July 2016 from Colonial. I'm assuming Mr. Cornwell is a senior manager with APRA,
That's right.
noting that Colonial had just discovered a subset of members in First Choice Employer Super who did not have their future investment weighting changed to MySuper in 2013 and have not had their ADAs flagged correctly in the registry system.
Yes.
And then you need to figure out how many offences had been committed in relation to those members.
Yes, that's right.
Attend to that document, Commissioner.
Letter Colonial First State to APRA 8 July 16 CBA 000104511377 Exhibit 5.193.
And then if we then come to CBA.0001.0451.1855, so this is now the 19th update in relation to Section 29, capital W, capital A.
Yes.
And by this stage, by the 1st of September 2016, the transfer, or the final transfer, at least for those 7,000 ADAs in First Choice Employer, is scheduled to be completed by May 2017.
That's the very last tranche, yes, that's right.
And attend to that document, Commissioner.
Email Colonial First State to APRA 1 September 16 concerning Section 29 WA update number 19 CBA 000104511855 Exhibit 5.194.
And then the last update seems to be if we bring up CBA.0001.0451.2600. So you see this is a response from APRA to update number 24.
Yes.
And it thanks the correspondent for the email and for providing the EY report.
Yes, that was the remediation. Yes.
Yes, Ernst & Young were commissioned to oversee the remediation.
Yes.
And they were undertaking that for several years,
Right, throughout
providing
the
updates.
tranches that you've described, yes.
And then on this date, APRA said we have no further queries and consider this item closed.
Yes.
Attend to that document, Commissioner.
Email APRA to Colonial First State 21 September 17 concerning Section 29 WA update number 24 CBA 000104512600 Exhibit 5.195.
Were you surprised at the end of this 3.5-year period that APRA never took any enforcement action with respect to Colonial First State for its many admitted contraventions?
No.
Why not?
We felt that we had worked through the contraventions and resolved them satisfactorily.
And I'm sorry, resolved them what?
Satisfactorily, that we had worked to rectify the situation.
You'd sought to obtain an investment direction or eventually move them over to the MySuper
And then
product.
remediate.
And then remediate. Now, there had been a concern, hadn't there, about the effect of the ADA transition on revenue?
Yes, we would have looked at that.
And if we bring up CBA.1004.0024.4850_E,
All right, can I have the number again, Mr. Hodge?
CBA.1004.0024.4850_E. I'll give a different number, CBA.1004.0024.4914. So this is a paper to the board of Colonial First State dated the 2nd of February 2016.
Yes.
And if we go to page .4916, this is the attachment to the paper, which is the 2016 three-year rolling business plan for both trustees.
Yes.
And then if we go to the page, which is .4930, see, this is in 2016 reporting back on factors that appear to be the major drivers of structural revenue margin decline.
Yes.
And you see that number 4, there had been a concern in relation to ADAs in section 29 WA that it would lead to margin decline.
Yes.
But despite initial concerns, it now seemed that it was unlikely that the ADA transition will negatively impact revenue margin.
Yes.
And so do you recall, this is obviously a couple of years later, deciding that there is no effect as it turns out. Do you recall that back in early 2014 there had been a concern about the ADA transition depressing revenue?
I don't remember that, specifically, but we would have been looking at all of the impacts on revenue across that time. Yeah.
Do you recall that when the MySuper product initially came into effect, that there was a concern that transitioning ADAs to MySuper would depress revenue?
Yes.
And that was a concern held by the board of Colonial First State?
I don't think the board ever discussed that, but management would have been looking at that, yes.
And do you say that had no relevance to recommendations that management then made about transitioning?
I don't recall. We were generally aware over this time that our revenues were going to change for, a number of the changes that were occurring in the industry at that time.
Attend to that document, Commissioner.
Board paper 2nd February 16 concerning Colonial First State Business Plan, CBA 1004.0024.4914, Exhibit 5.196.
Do you recall that in 2014, when the issue of the contraventions of 29 capital W capital A came up with APRA, that APRA suggested accelerating the transfer of ADAs over to MySuper?
Yes.
And was it the case that the board of Colonial refused to do so?
There was, I do recall the board being reluctant to do so, yes.
And why was the board reluctant to do so?
Because of the operational risk in the business at the time. We had declared the business out of risk appetite due to the number of technology projects that were occurring at the one time, and there was a concern. You saw we were doing the ADAs in tranches. There was a concern that if we tried to bring forward the ADAs, that there might be operational risk.
Well, they were being done in tranches because they were identified in a tranche as an offence
Yes.
occurred.
Yes, that's right.
So the initial tranche was all of the initial 13, or as it turned out, I think 15,000 offences.
Yes. Yep.
And then what had occurred was, wasn't it, that it was assumed that initial group of 15,000, to the extent that they didn't provide an investment direction, would be the only group that would need to be moved over to the MySuper product.
Sorry, I'm not sure I followed that.
I'll put it another way. The initial plan to move the initial 15,000 over to the MySuper product was to occur because there had been contraventions in respect of them.
That's right.
And then, as it turned out, as new contraventions arose,
New tranches, yes.
in respect of members, those members where there had been a contravention would be grouped up into a tranche and then transferred over.
That's right.
So that was why the tranches occurred. They just occurred as Colonial committed offences.
What I'm saying is that what we ended up doing was we did end up accelerating, moving it all across, because that obviously stops the reoccurrence. And there was a reluctance by the board to do that at the time that I know it is in a board paper, because of the operational risk involved in doing that.
And was there some paper prepared that identified that operational risk?
Well, the risk appetite statement that we have, the board had, we had declared that we were outside of our risk appetite in relation to the number of IT projects that were underway at that time.
So that I can make sure that the Commission understands this. Colonial was already undertaking a number of IT projects,
Yes,
and the number that it was already undertaking was outside of its risk appetite.
well, the overall, yes, that's right.
So to add one more computer project would be outside of its risk appetite.
No, because we were outside of risk appetite.
You're already
We
outside of
didn't
risk
want
appetite.
to risk errors or problems with such a big, these are very big, complex transitions, and the board had concern that the transition would only occur when we were confident that there wasn't going to be that kind of error with it. That's as I remember, the conversation. There may well have been other factors in the decision. That's what stands out
That's the
to me.
principal consideration that you can recall.
That's the one that I recall.
What I'm trying to understand is that one consequence of not implementing a computer project to move the ADAs over to the MySuper product is that Colonial is going to court offences. You understand what I mean? That is, it's going to take the chance that it is going to continue to contravene Section 29, capital W, capital A.
I think we felt with the tranches that we had an appropriate mechanism in place.
I don't know whether we're disagreeing with each other. The tranches arise after an offence has occurred.
Yes.
So one thing that you're saying Colonial did was to decide that rather than implementing a computer project now to transfer the members over, it would just accept that there would be more offences, and as each offence occurred, it would bundle those members up and transfer them to MySuper.
Yes.
And another aspect of this that seems to be missing is there's presumably a question of whether it is in the best interests of the member to be in the MySuper product rather than in the particular investment option that they're in at that time. Do you agree?
Yes.
Was there any analysis performed that was presented to the board to indicate whether most members would be better off by being moved over to the MySuper product?
I don't recall it being presented to the board. There was discussion about that, and the management team were looking at what the impacts were, what the differences between the staying where they were and the MySuper were as well.
And does it strike you now with hindsight as strange that the board would elect not to implement this computer program or process because more computer processes are outside of risk appetite without having detailed information about whether or not it would be in the interests of most members to move over to the MySuper product?
I think at that time, the board did think that was the right decision that it had made.
Yes. What I'm asking is now, with the benefit of hindsight,
Yes, we should have done more analysis, I would agree.
and do you agree that if you were to act in the best interests of the members, you would have to do more analysis?
It would have been preferable that we did more analysis.
Do you agree that it's not possible for you to know whether you are acting in the best interests of the members without doing more analysis?
The analysis that we had done, I guess, led us to believe that that was the case. I do accept when I look at this that the breaches were top of mind and there could have and should have been more analysis, yes.
Sorry, what was the analysis that you say had been done?
The product managers had been doing analysis around what the differences between where members were and the MySuper option.
But they hadn't reported that to the board.
I think I can't recall, and I haven't seen, reviewed the documentation. There was discussion, but I think you're right. I think I would agree from what I have seen that there's insufficient evidence that was done as robustly as it should have been.
So that we can just make sure that we're talking about the same thing, can we bring up CBA.1004.0020.1247? CBA.1004.0020.1247. I'm sorry, I said a 1 instead of a 0. Would it help if I said
Not a happening thing, Mr. Hodge, not a happening thing.
CBA.1004.0020.1247?
One of us is dyslexic, at least, Mr. Hodge.
Have I just said a different number?
Oh, possibly.
Well, we've got there now. So, Ms. Elkins, these are the board meeting minutes for a meeting of the 30th of April 2014.
Yes.
Are these, if we bring up pages 2 and 3 of this document and put it on the one screen, we're just trying to put together the timeline of this. So you see there's an item starting at the bottom of page 2, which is contributions received without member investment direction.
Yes.
Could I ask you to look at that and tell me whether this is the discussion that you're thinking of?
Yes, that's the board meeting. Actually, I'm sure the issue was discussed at other board meetings, but yes, this is the board
This is
meeting.
the particular one that you're thinking of. And in the second bullet point on the second page, it says, noting that CBA is a related party and having considered the options, it is in members' best interest to transfer affected members' ADAs to CES where a valid direction cannot be obtained.
Yes.
And just so we're clear on what each part of that means, the affected members' ADAs that means members who are affected in the sense that there has been a contravention of section 29, capital W, capital A.
Both them and the other ADA members in personal, first choice personal.
Oh, I see.
Yeah,
And also,
the ones
other
who weren't
ones.
contributing.
sorry, are you saying it's just the ones who are contributing?
I think this refers to both, that Commonwealth Essential Super's being selected as the MySuper product for all of the ADAs.
Yes, and Commonwealth Essential Super is that other
Yes.
MySuper product
Yes,
in a different fund
yes,
that's recently been established for CBA to sell through its branches.
yes,
So what's resolved is that it's in the members' best interests to transfer those affected members over to CES.
yes,
And then it said, it's noted that any changes to the trustees' transition plan giving effect to the proposed remediation will be tabled at the next board meeting.
yes.
And I tend to that document, Commissioner.
Board pack 30 April 14 for Colonial First State Investments Limited, CBA 100400201247, Exhibit 5.197.
And then if we bring up CBA.0001.0451.0267, so this is an email from Ms. Smith of Colonial,
Yes,
and it's to David Shade, who we understand is from APRA,
yes,
and you can see it's copied to a number of people, including you.
yes,
And you see in the first paragraph, it's referring to an email that has already been sent to Ms. Ellis back in May of 2014, advising of what decision the board had made.
yes,
And it says, after careful consideration, the board, after careful consideration, did not approve bringing this forward, given the potential operational risk associated with undertaking a significant transaction at this point in time with the regulatory reform projects currently underway.
yes, sorry.
And does that affect the answer that you gave earlier as to what it was that the board was deciding in April? Let me explain.
Sorry. Yep,
Isn't this saying that the board is not going to accelerate the transition of the other members in first choice personal super, which could only be members with ADAs? The only people it's going to accelerate are the members where there's been a contravention of 29WA.
yes, sorry, I thought that's what we were talking about before.
Oh, we agree. That
Yeah.
is, maybe I thought we
Sorry.
were disagreeing. There was something like 70,000 members
Yes.
who had been identified as having ADAs within
Without
first choice personal super.
Mhm.
Is that right?
I think it was 60,000, but, yeah,
60, whatever number it is.
yeah,
And there was initially only a subset of 15,000
we're
of
in
them
breach, yes.
where there'd been a contravention of 29 capital W capital A. And we are both agreeing, I think, that the board approved the accelerated transitioning of the members where there had been a contravention over to the MySuper product, unless an investment direction had been given.
So that was the tranches,
Yes.
yes,
It didn't approve an accelerated transition for members who weren't in the tranches.
not at this stage, no,
At some later time it did.
yes,
And again, if we come back to the explanation you were giving us earlier, the principal reason, as you recall it, for not accelerating the transition was a concern about being outside of risk appetite in terms of the number of projects on foot.
the operational risk, which is the first bullet point here.
But you're already going to be transferring 15,000 members from
Yes.
First Choice Personal Super over into the MySuper product.
So it's very different to do the smaller tranche than it is to do the bulk, I think was the issue.
I see.
And there's other, I don't remember the other reasons as well as I remember the operational risk issues.
Well, the third reason, the low probability of breaching Section 29, capital W,
Yes,
capital A
sorry,
in the
we
future,
discussed that as well,
that
yes.
definitely didn't pan out. Do you agree?
Again, my recollection of that was more about that we had a method of dealing with it, the tranches.
I see. So,
And there was some, I think there was some manual controls as well.
I see. But you're saying you don't think it was ever thought there was a low probability of breaching the section in the future. It's just that once it was breached, there was a method of dealing with it.
I'm not sure. Obviously, the person, yeah.
You're not sure?
I might be losing some of the detail
What?
from then. That's my recollection.
And then you see the last dot point is the work already planned to engage with the relevant members and advisors regarding their intentions.
Yes.
And that brings us, I think, neatly to the next topic. Can I tender that document, Commissioner?
Email Colonial First State to APRA 4 July 14, CBA 0001 0451 0267, Exhibit 5.198.
Now, one of the things that Colonial was doing throughout 2014 was contacting advisors to talk to them about getting investment directions from their members.
Yes.
And I want to show you some examples of that so that we can understand the particular process. If we bring up CBA.0001.0457.0095, so this is a little later, so this is mid-2015. This is an email between an advisor, Mr. Williams, and Mr. McAuliffe, who's a relationship manager within corporate superannuation.
Yes.
Is a relationship manager, is that somebody who you would classify as being in this intermediary team?
Yes. Distribution, yes.
And that is dealing with the advisors.
Yes.
And you see, if we go over to the page .0097, this is because, or what prompts this chain of emails is that Mr. McAuliffe, the relationship manager, is sending an email to the financial advisor with a list of the financial advisor's clients that have an accrued default amount.
Yes.
And then if we go back to the first page, .0095, we see the response is, if I read these correctly, the attached are around $57 million of assets at, say, 0.33% per annum, means 188,000 plus insurance commissions could be lost if we do not get them to change or confirm their investment option. Is that right?
Yes.
And then the response from Mr. McAuliffe is to explain that, yes, that is right. That if there is no investment direction given, the commissions will be lost.
Yes.
Tender that document, Commissioner.
Emails between McAuliffe and Williams 1 May 15 concerning accrued default amounts, CBA 0001 0457 0095, Exhibit 5.199.
And if we then go to CBA.0001.0452.1313, So this is Mr. McAuliffe again emailing another person who we understand to be a financial advisor.
Yes.
And you see about 2 paragraphs down, these people have what is known as an accrued default amount, aka an ADA. ADAs need to be transferred to a MySuper option by 30 June 2017. There is no timeline as yet for when CFS will commence moving these ADAs to the life stage option.
Yes.
And the life stage option is the particular MySuper product that Colonial had put into the fund.
Yes.
And just so we're clear about this, because under the legislation you could have either a single diversified option or a life stage.
That's right.
So Colonial was using a life stage.
Yes.
And then it's explained that at the moment the relevant financial planning business is receiving grandfathered trail commission on these ADAs.
Yes.
And at the bottom of the page, in the second last whole paragraph, you'll see what it shows, this is in relation to the data analysis, is that there are around 148 active TF accounts, and 79 of these have an ADA, meaning that 69 have provided an investment direction, meaning that what they will have in place right now will continue beyond 30 June 2017, and grandfathered trail will also continue.
Yes.
And then in the next paragraph, with regard to our other discussion, grandfathered trail commission can continue when changing licensees. And then there's an explanation of Colonial's interpretation of the grandfathering rules.
Yes, that's...
And that reflects, oh, I'm sorry.
I don't know if that is correctly our interpretation, but that is what this...
Oh, I see. It may no longer be the position that Colonial takes about the changing of
I'm not sure.
licensees. All right, attend to that document, Commissioner.
Email McAuliffe and Bennett 29 September 15 concerning MySuper accounts, CBA 0001 0452 1313, Exhibit 5.200.
And if we then go to CBA.0001.0459.1788, you see this is an email from somebody else within Colonial First State over to some financial planners.
Yes.
And can I suggest, you may or may not know this, that this is effectively a standard form type of email that was being sent out to financial planners by Colonial First State?
It may have been. You're right.
You're
I
not
don't
sure.
know.
You're
No.
not sure. All right. And it's explaining the approach or the timetable for changing over, for transferring ADAs over to MySuper.
Yes.
And it makes the point at the end of the second paragraph, as you're aware, MySuper products do not pay commissions.
Yes.
And then you see a heading which is what we've done so far.
Yes.
And it said over the past year we've worked hard to contact investors with an ADA account via an extensive email, mail and direct call-out campaign to ask that they confirm their investment direction.
Yes.
And were you aware of that extensive email, mail and direct call-out campaign?
Yes, that's the... Yes, I was. Yes.
Well, I think it may have, what you were about to say was that's the call script and letter we'd already looked at.
Yeah, there were other as well. Yeah.
That ultimately built up into a more expansive call out.
I don't know if it was more, but yes, there was. You know, exactly the design of that and exactly how many, I'm not sure, but yes, there was.
And the approach that was taken was the same as the call script and letter that we've already seen, which was to try to obtain an investment direction from the members,
Yes, that's right.
as distinct from provide the members with information so that they could assess whether they were better off or worse off under MySuper.
There were different call-out campaigns. So, yeah, again, I can't say across the board, but there were different.
I see. The reassurance, can I suggest, that Colonial First State is offering to advisors by this form of email is that Colonial has itself put the effort in to try to obtain the investment direction,
Yes,
and obtaining the investment direction means the member won't transition to MySuper.
yes,
And as the email says, MySuper doesn't get commissions.
that's right.
And so the reassurance being offered by Colonial First State to its advisors is we've done what we can to try to keep commissions for you.
That wasn't, this was about, in our minds, this was about having clients and their advisors discussing the options. But you're right, that's the effect. Yes.
But it can't have been about having clients and advisors discussing the options, because the entire point of the extensive email, mail and direct call-out campaign was to get the investment direction without the advisor having to do anything about it.
That wasn't what we intended, but I can see that.
But it must have been what you intended, because that's what you're telling the financial advisors. Over the past year, we've worked hard to contact investors with an ADA account via an extensive email, mail and direct call-out campaign to ask that they confirm their investment direction.
And the driver for that was that we believed that people had made, or with their advisors, needed to consider which investment direction that they wanted. To stay where they were or to move to MySuper.
Oh, so you thought this would prompt them to then talk
Yes.
to their advisors. I tender that document, Commissioner.
Email between CFSL and Financial Planners 6 July 16 concerning CFS update, transfer ADA accounts, CBA 001045911788, Exhibit 5.201.
And actually, just before we bring that down, if we look down about 2/3 of the way down the page, you see the heading, what can advisors do?
Yes.
And it said advisors can assist any of their impacted clients by contacting them and asking them to confirm their investment direction using the relevant form.
Yes.
And do you say that means something different from this, which is advisors ought to contact their clients who have ADAs and get an investment direction from them to avoid the ADAs transitioning to MySuper?
Well, it wasn't to avoid it. It was if they agreed that that wasn't what they wanted to do.
There's no information
No, I
that
do
is
accept
provided.
that. I agree.
And the only reason, can I suggest, why you would not provide the information is because the information as to whether the member is or is not better off in moving to MySuper is irrelevant.
No, I don't agree that it's irrelevant, but I do agree it should have been provided.
What is relevant is the thing that is stated. As you are aware, MySuper products do not pay commissions.
Well, yeah, that is what it says.
If we go over the page to .1789, this is setting out the attachments, and we see a data file containing all clients with an ADA account balance and their advisor details,
Yes.
and a data file containing all clients with an ADA account balance and their advisor details for first choice employer super.
Yes.
And then it said total exposure for PIS for FCPS. Could you explain to the Commissioner what PIS is? Oh, I'm sorry, PIS is the financial planners, I think.
Yes.
So total exposure for this financial planner for first choice personal super is $1.96 million.
Yes.
And total exposure for this financial planner for FCES is $24.6 million.
Yes.
And this is the exposure in terms of the value of assets that are presently in ADAs,
Yes.
but will transition over to MySuper without an investment direction,
Yes.
and thereby lose commissions.
Yes.
And that's why it's an exposure for the
Yes,
financial
that
planner.
is what that would be referring to.
Now then, a few months later, there's then a second stage to this email campaign, which is to give a reminder to advisors, and I'll bring up CBA.0001.0459.1839. So you can see on the bottom half of the page is an email back in July, which is that standard form type of email we've already looked at.
Yes.
And then at the top of the page is the reminder, which is we are quickly approaching the November transfer of accrued default accounts, accrued default amount accounts.
Yes.
As you're aware, a number of your advisors have exposure to these accounts, which will be transferred if no action is taken. As at 1 July, and this is the financial planner, funds under administration, which will transfer, was $21.6 million.
Yes.
And again, it would appear on its face that this is an email to encourage an advisor to stop the ADAs transferring over to MySuper by obtaining an investment direction. Do you think it served a different purpose from that?
I think it did, but I do accept that on its face it is also doing that. Yes.
And the different purpose was what, to get the financial advisor to engage with the member?
Mm.
Yes.
Attend to that document, Commissioner.
Email CFSL to Financial Planners, 16 September 16, CBA 0001 0459 Exhibit 5.202.
Now, you, I think, was, as I understood it, you were saying you knew that there was this call-out campaign and mail-out campaign.
Yes.
Would you have approved the campaign?
No. No, I didn't.
Somebody else approved the campaign.
That's right.
And were you aware of the, what I'll call the campaign to contact advisors?
No, not specifically, but no, I wasn't aware of that.
Can we bring up CBA.0001.0479.0817? So this is the outbound call guide for ADA campaign call-outs.
Yes.
And you see there's this box at the beginning which is background.
Yes.
So this is presumably the instructions that are being given to the call centre operator.
Yes.
And then you see that there's a heading about halfway down the page which is what is success?
Yes.
And success is described this way: contacting client, letting them know that a change is coming to their super which may result in an increase to their ongoing annual fees, costs and insurance premiums, they need to be aware that they can opt out of this transfer and avoid an increase in fees and premiums if they confirm their investment direction with us.
Yes.
Is this the generic script that was being used for the call-out campaign, or you're not sure?
I don't believe so. I'm not sure, but when I look at that, I think this was the script that was used for the people that were identified to currently have lower fees
Oh, I see. You think this is a script
to a
specifically?
particular cohort.
Okay.
Again, I can't be certain, but when I read it, that's what I assume. And I know those scripts were developed, different scripts for different cohorts.
If this wasn't a script for that specific cohort, then this statement here would be problematic, wouldn't it?
Yes.
Because it's not true. Or you couldn't know whether it's true.
If you applied it to the wrong cohort.
And then if we go over the page, this is part of the call script, and you see if this transfer proceeds, your ongoing fees and costs may increase.
Oh, sorry, where are we?
You see about a quarter of the way down the page.
Yes.
And then it says, this could make a difference to your super, so we want to make sure you have the opportunity to decide whether or not you want your impacted balance to be transferred to the life stage option. We want to make sure you're aware that you can opt out of this transfer by confirming your investment direction.
Yes.
And do you agree with me that if this is the script being used for all members, rather than members that have been specifically identified as having fees that will be higher under MySuper, then these statements are misleading?
I think I'm a bit lost now. Is that the same script, or is this a
Yes,
different
this is
one?
part of the same script.
If it was applied to the wrong cohort.
Right, but you think this may be only applied to a
It was my understanding that we were identifying particular cohorts and calling them based on what they were.
I see.
I can't
Presumably,
tell you for sure that
I see.
that was my understanding.
Attend to the script, Commissioner.
Call script outbound call guide ADA campaign CBA 0001 0479 0817 exhibit 5.203.
And then if we bring up CBA.0001.0436.5386, so this seems to be the template letter that was sent out to members.
Yes.
And you see the beginning says, it's important we let you know your first choice personal super account will be transferred to Commonwealth Essential Super in August 2016 unless we receive certain information from you.
Yes.
And then it says, the heading is, how do you stop your account being transferred?
Yes.
And then there's a heading below which is, what happens if you do nothing?
Yes.
And item 3 is any insurance cover in first choice will cease.
Yes.
And item 4 is insurance cover in essential super is different and the
Yes.
level of cover and premium cost may not suit your needs.
Yes.
And item 5 is there will be transfer costs.
Yes.
And can I suggest this letter is obviously drafted in a way to make the member concerned and apprehensive about their ADA being transitioned over to MySuper.
I agree that this letter is not balanced.
I tender the letter, Commissioner.
Template letter 29 April 16 CFSL to members CBA 0001 0436 5386 Exhibit 5.204.
No, I'm sorry, Ms.
Oh,
Elkins,
I
I think
was
we
just
interrupted.
going to say there was a second part to this that did set out. I believe this letter also had a comparison attached. I can't be sure, I can just see on here it says, we strongly recommend you read the enclosed flyer. It doesn't change what I've said. The first page of this letter is not balanced.
Oh, I see. The
Yeah.
flyer, what will happen to your super? That's the point you're making.
No, sorry, but I think, I'm not sure, so, and I accept that that's not balanced.
Now, one of the other aspects of this, can I suggest, is if there was no longer any advisor listed on the account, then Colonial was retaining the trailing commission.
Yeah, that's effectively what would happen.
And if a new advisor became the advisor to the member, the trailing commission wouldn't start being paid to them. That if it was after 1 July 2013.
That's right,
Because you weren't permitted by FOFA to start paying it to them.
that's right.
And so instead, Colonial would just hang on to the commission.
Yes. Well, the fee would be higher, that's right.
And are you aware that there have been some issues raised by financial advisors about the description of products as commission-free when in fact Colonial is retaining the trail commission?
I'm aware there's been advisors raise the issue with us. I'm not sure about the link to commission-free. I think that's referring to something different.
Oh, I see. There's one issue was there are some financial advisors who will rebate the commission back to their clients.
Yes,
And a complaint from one of those advisors was that they couldn't rebate the commission back to their client because Colonial was retaining it.
yes,
And that's been an issue that's been ongoing, I think, well into this year. Is that right?
yes, it has.
Maybe if it would help, I might bring up some documents. If we bring up CBA.0001.0457.3454. Commissioner, I think we did tender that one. So this is a chain of emails between a financial advisor, Mr. Jopling, and Mr. Tully.
Yes,
And this begins, it becomes a little bit hard to follow, but if we go to page .3461, so you'll see at the bottom of the page there is another email that's being responded to by Mr. Jopling. You see right at the bottom of the page from Darryl Jopling.
yes.
And then if we go over the page, we can see what that email was. Can we bring both up on the screen? So Mr. Jopling's asking for the MER of some commission-free accounts.
Yes,
And then there's a response from somebody from Colonial as to what the management costs are.
yes,
And then if we can now have up on the screen pages .3460 and 3461. you see Mr. Jopling replies to that on the 24th of January to explain that the accounts that he's referring to are designated as commission-free accounts. See that at the bottom of the page on the left-hand side?
Yes.
And he says, I have checked the Morningstar website, and for a normal MIF, what's MIF? Is that managed investment
Yeah,
fund?
it's a unit trust.
Without commission altered, the indirect cost ratios are as follows, and then he sets it out.
Yes.
And then over the page he says, with the trailing commission built into the MIF product of 0.44% as standard, I would expect a commission-free account to have a MER. And could you just explain what MER is?
They manage the cost. Managed
That's
expense
is a
ratio.
management expense ratio,
Mhm.
reduced by the 0.44%, not the amounts you have listed below.
Yes.
And what Mr. Jopling is trying to figure out is what's happening with the trailing commission, and because he wants to rebate it to his clients.
Yes.
And then if we then bring up on the page .3458 and .3459, I'll bring up on the screen, I'm sorry. We see the response on the 31st of January from the customer contact representative of client operations of Colonial First State is to say, thank you for contacting Colonial First State Advisor Services with your inquiry. The accounts are commission-free accounts, therefore commission is retained. And that means, as we understand it, the accounts are described as commission-free, but in fact they include the amount for commission, and Colonial keeps it.
I'm not sure where the reference to being commission-free. Yes, that is what the correspondence says.
And then this then goes on for a couple of months until we get to, if we go to page .3454, it's risen up to the level of Mr. Tully, who is the Business Development Manager for Retail Sales.
Yes.
And Mr. Tully tells Mr. Jopling on the 9th of March that Scott, who is Scott? You're not sure? Oh, Scott Hendricks.
Operations. He leads the operation.
He was interested in the situation, and it's been sent off to risk compliance, and Mr. Tully will keep Mr. Jopling in the loop. And then we can see at the top of the page, Mr. Jopling writes again on the 19th of March 2018, asking colourfully where things are at.
Yes.
I
attend to that email chain, Commissioner?
Emails between January and March 18, Jopling, Tully and others concerning MIF, MER question, CBA 000104573454, Exhibit 5.205.
And then if we bring up CBA.0001.0457.4183, so Mr. Jopling keeps pursuing the issue. You see he emails on the 20th of March, and then he emails on the 23rd of March and says hopefully the findings of the Royal Commission, the 23rd of April, and says hopefully the findings of the Royal Commission can help CFS to make a quick decision to benefit the client. And then he emails on the 28th of May and says probably a silly question, but any chance that clients are closer to getting their commission back? It's starting to mount up. Have you seen these documents in the course of preparing?
In the course of preparing, yes, I have.
I tend to that chain of emails, Commissioner.
Emails between Jopling, and Tully, March to May 18, CBA 0001 0457 4183, Exhibit 5.206.
And there had been some internal issue raised about this. If we bring up CBA.0001.0457.3756, so this is an internal email where the situation is explained, which is Colonial First State Investment Limited's distribution have received the below complaint from an advisor, Mr. Jopling, who's from Dover. The query was originally handled through the contact centre, so may have already been escalated through to GCR. What is GCR?
Group Customer Relations.
If this is the case, would you please advise outcome? Similarly, my distribution colleague, Mark Tully, may have raised through Distribution Plus, which may mean the case is already in First Point. Do you know whether the issue has now been resolved?
The issue hasn't been resolved, but the issue is under review, yes.
And how can the issue be resolved, do you know?
We would need to decide that we're going to reduce the fees on these products and build the capability to rebate it to clients, yeah.
Presumably one way to resolve it would be to say we're not going to have trailing commission anymore on these products.
Yes, that would be one way. Well, we would still need to lower the fee, obviously, to take that out, yeah.
And then you'd reduce the fee because you're not paying
Reduce the
trailing
fee.
commission
That's
anymore.
right, yes.
Right, I tender that document, Commissioner.
Emails between Swetland, Sutil, Tully and others, April 2018, CBA 0001 0457 3756, Exhibit 5.207.
Has Colonial considered reducing its commission?
Colonial is in the process of considering that, yes.
Right. It hasn't made any decision.
It hasn't made
As
any
of yet.
decisions.
And when Colonial makes that decision, in what capacity is it going to make that decision?
I think I'm kind of struggling with what the correct legal process for that would be.
One of the challenges for Colonial is this, isn't it? That it is the trustee of a superannuation fund,
Yes?
and it's also the responsible entity for a managed investment scheme.
Yes.
It has the DRE structure where it's the contributions or assets of the superannuation fund are invested in a managed investment scheme of which
Yes.
it's the responsible entity.
Yes?
And it also has a relationship with advisors and advice licensees.
Yes.
Now I may be misremembering this, it's not itself an advice licensee, is it?
No.
But it has related entities that are advice licensees.
CBA has advice licensees, yes.
And in turn, those advice licensees have corporate authorised representatives and authorised representatives.
Yes.
And there's a Colonial Financial Planning, isn't there?
No.
Oh, there's Commonwealth Financial Planning.
Commonwealth Financial Planning.
I see. That's owned by CBA,
That's right.
not owned by Colonial First State.
That's right.
Okay. And so it presumably has many competing interests all around it. It has its shareholder who owns financial planning businesses, and it's the trustee and it's a responsible entity.
Yes.
So when its management comes to make a decision about whether or not it will give up commissions, how does it do that?
Well, we would do it, a recommendation would come in our corporate capacity. Yeah, I mean, we're undergoing this process now, so I think that it could, that kind of decision could arise in more than one way. I think once the recommendation is made, I mean, if you're talking about if Colonial is going to make a decision to cease paying commissions, I guess the effect of that on our aligned licensees is the same as on the unaligned. I don't see that as being different.
That is, they will lose revenue.
Yeah, that's right. And whatever the legal construct of that is will be the same.
As the trustee, though,
Mhm.
it has to only act in the interests of the members.
Of the members, that's right.
So when it faces an issue like we're charging trailing commission and then retaining it ourselves, how does it handle that in the interests of the members?
Yeah, so that decision isn't a decision the trustee made. The commission paying products always work that way. So yes, I think if that decision was presented to the trustee board, they would be unlikely to make that decision.
Oh, I'm sorry, you're saying none of these products they're all managed investment scheme products?
Oh,
Is
the
that-
one you were looking at is,
Yes.
but I'm saying the fact that the commission is paid out of the fee
Yes.
is how commission paying products always worked, and we haven't changed that.
Yes.
So it's not a decision that's been before the trustees to make a decision to do that.
Do we agree that there are products issued by the trustee that have a trailing commission built into the fee?
Yes.
And do we agree that there, in the case of some of the members who are in those types of products, they do not have a linked advisor?
Yes.
And do we agree that in those circumstances, the amount for trailing commission is retained by somebody?
Yes, that's right.
And who is it retained by?
By Colonial.
By the trustee.
Well, in corporate capacity, I guess. I mean, yes. Yes.
I see.
that is what
It's, I understand what you're saying, which is it's retained by Colonial, it's not paid into the trust fund.
That's right.
And am I understanding you to say Colonial just hasn't yet considered how doing that could be in the best interests of members?
Colonial is now reviewing, is now considering across the board what we need to do in regard to our commission paying products.
I see.
And is this the first consideration you've given to it?
Yes, prior to that, we, yes, it is, yes, other than the introduction of FOFA and complying with the grandfathering provisions.
Is there any earlier occasion on which you have considered issues that could be said or could be described as arising from the fact that Colonial wears a number of different hats?
No.
I want to move to a related topic in relation to commissions, which is concerned with another particular issue, which is when a member changes to a pension.
Yes.
And there was also an issue that arose in relation to commissions
Yes.
in that respect for Colonial. Just before we get that, and so that I can not have lost something else, can we bring up CBA.0001.0446.0022? This is an internal email of CBA, which you'll see is sent by Ms. Rubenstein and to a number of people, including you.
Yes.
And it refers to productive meetings with the Chief of Staff to the Assistant Treasurer and also to Treasury.
Yes.
And you see that this is on the 13th of February 2015.
Yes, sorry.
And you see the fourth point there is ADA issues suggested we talk to Treasury.
Yes.
Do you know what the ADA issues were that Colonial was raising with the Assistant Treasurer and Treasury in February of 2015?
I don't. I would guess, looking at this, I don't believe I was in this meeting. I would take that to mean, what date was it, sorry?
This is 2015.
No, I can't be sure.
You're not sure what it is. All right, I tender that document, Commissioner.
Emails Rubenstein to Elkins and others, 13 February 15, concerning summary of Canberra meetings, CBA 0001 0446 0022, Exhibit 5.208.
Now, a matter of a problem that Colonial had was the grandfathering of commissions when there was a transfer from superannuation to pension.
Yes.
And if we bring up CBA.001.0449.0019, is this a document that you've seen before?
I've seen it in preparation, yes.
All right.
I think I have, actually, yeah.
Do you know what OSG is?
Something steering group, operational steering group, something.
And
Yeah.
you see this is a presentation dated the 10th of February 2015.
Yes.
And if we go to page .0020, so this is the second page of the presentation, seemingly weighing up the risks of continuing or not continuing grandfathering of commissions
Yes.
for a transition from super to pension. And it identifies that the revenue at risk is $2 to $10 million per annum.
Yes.
And could you just explain to the Commissioner, what does it mean that that is the revenue at risk based on not...
I'm not sure how that number was derived. I would have thought there was a number of factors that they would have input into coming up with that number. That's I noticed on the front of this pack it's the regulatory reform team, so there would have been analysts looking at that question.
Okay. You're not sure,
I'm not sure what the factors that fed into that number are.
but the revenue...
Is our revenue.
That's right, the
That's my
Colonial Group
interpretation of
revenue.
that. Is it may be advisor revenue, but I suspect it's ours.
Okay. I tender that presentation, Commissioner.
A review of grandfathering super to pension, 10 February 15, CBA 0001 0449 0019, Exhibit 5.209.
And what happened was that Colonial didn't stop grandfathering commission from super when there was a transition over to pension.
Initially, there was change in the regulations that required us to subsequently do that, yep.
Well, that's not quite right, is it? What happened was FOFA came into effect from 1 July 2013.
Yep.
And it required there to be no commissions paid on new products entered into after 1 July 2014.
Yes.
So I think I said it came into effect on 1 July 2013,
that's
even
it.
that's not quite accurate. It
That's
came
right,
into
yeah.
effect in 2012. Agreements had to be in
That's
place by 1 July 2013.
Yes,
You couldn't pay commission on a new product entered into after 1 July 2014.
yes,
And when there was a change of government, the new government had committed to rolling back FOFA in some respects.
yes,
And the new government put up regulations that would have delayed the start of, or extended out the time in relation
I
to
don't
FOFA. You're not sure of that?
specifically remember the...
In any
yeah.
event, the new regulations would have changed the 1 July
Yes.
2014 effect. And then they were disallowed
Yes,
in the Senate.
yes,
And so the consequence was there was a brief period of time when Colonial thought it wouldn't have to comply with the full FOFA, and then it did have to comply with the full FOFA.
I'm not sure if that's... to, make a change.
And then if we bring up CBA.0001.0456.0953, this is a letter dated the 29th of May 2015 to ASIC.
Yes,
Is this a letter you've reviewed in the course of preparing to give evidence today?
I think so, yes.
Do you recall that CBA, on behalf effectively of Colonial, sought a no action letter from ASIC in relation to its continued payment of commissions in relation to the
Yes,
super to pension transition?
yes,
And CBA put up some arguments as to why it is that it might be permissible to continue with the fees.
yes,
And one issue which I note, really for the benefit of the Commissioner, is if we go to CBA.0001.0456.0959, you'll see that CBA flirts with the idea that perhaps Colonial First State, as trustee of the super fund, is a platform operator,
yes,
and then it would be able to grandfather commissions.
that's the idea that they're floating, yes.
But then ultimately, it doesn't press that point,
No.
and it seeks the no action letter and an extension period in order to comply
Yes,
through to 1 October 2015.
yes,
I tender that document, Commissioner.
Letter CBA to Commissioner Tanzer, ASIC 29 May 15, CBA 000104560953, Exhibit 5.210.
And if we bring up then CBA.0001.0456.1399, this is the response from ASIC to the request for a no action letter.
yes,
And again, did you review this in the course of preparing to give evidence?
yes,
And if we go over the page to page 2, there's an explanation from ASIC about its facilitation approach in relation to compliance following the disallowance of the regulations.
yes,
And it says, in effect, that it's allowed entities making a reasonable effort to comply with the law by 1 July 2013 to do so, and in those circumstances, ASIC wasn't going to take action for inadvertent breaches.
1 July 15.
I'm sorry, 1 July 15.
Yes.
Thank you, Commissioner. But in respect of CBA, you can see in the middle of the page it said, while we do not have enough information to determine whether the licensees were complying with ASIC's facilitated compliance approach, we note that based on information available, it does not appear that the licensees were making reasonable efforts to comply with the law by 1 July 2015.
Yes.
And what then happens is ASIC won't give a full no action letter. It instead gives a qualified or limited no action letter.
Yes.
I tender that document, Commissioner.
Letter ASIC to CBA 22 July 15, CBA 0001 0456 1399, Exhibit 5.211.
And this prohibition on continuing grandfathered commissions when there was a transition from superannuation over to pension, that was something that you had personally lobbied against?
I'd lobbied for clarity around it, yes.
Let's bring up CBA.0001.0446.0003. So this is an email of the 25th of October 2013. It's an internal email, but it's recording a meeting that has occurred between a number of people on behalf of CBA, including you.
Yes.
And it's a meeting with certain Treasury officials and an advisor to one of the then ministers as part of a confidential consultation with industry on FOFA issues.
Yes.
And one of the things that you were lobbying for was the removal of opt-in and fee disclosures.
I don't think I was, that's wouldn't have been my area of expertise in this meeting.
Was that the
And
position?
I don't remember it to be a removal of it.
I
I
see.
thought it was some aspect of clarification.
A limitation of it, in some respect.
I'm not sure. As I said, that wouldn't be my area of expertise.
If we go over the page to .0004, we see there's a heading which is grandfathering,
Yes.
and the second point is first choice super to pension issue, grandfathered commissions. Treasury explained the regs were not intended to impact super funds where single interest covers super and pension accounts by ceasing grandfathering. Treasury would consult with Colonial First State offline to resolve a win.
Yes, that's what it says.
When you say you were seeking
Clarification.
yes, I think
Yeah.
that's right. You said you had lobbied for clarity
Yes.
around it.
Yep.
It was more than that, wasn't it? You were lobbying to be able to grandfather commissions when it went from superannuation to pension.
Yes, we were, and for that to be consistent, just, not different based on the product structure.
And at the time, that is in 2013, you were a director of Colonial First State.
Yes.
And as we've talked about already, Colonial First State obviously has many hats, but one of its hats is to be the trustee of the superannuation fund. How was it in the interests of the members of the fund to grandfather commissions when going from superannuation to pension?
So we were, I was supportive of the grandfathered arrangements within FOFA. And as I said, the lobbying effort we were making was to get clarity and the same treatment across the board for the way grandfathering was treated between super to pension. And we were also of the view that some people would choose to pay for their advice by the commission structure.
How is it in the interests of the members of the fund to grandfather commissions when going from superannuation to pension?
In hindsight, I would agree that it's not, and we, shouldn't have been lobbying for that.
Now, this also means that, at least from October 2013, Colonial understood that if the regulations didn't pass, then the consequence would be that commission was prohibited when the product changed over from super to pension.
Yes.
Do you agree?
Yes.
And so in those circumstances, how did it come to be that Colonial was still paying commission on the pension product after 1 July 2014 and after the regulations hadn't passed?
I don't think I can recall sufficiently how that occurred.
Attend to that email, Commissioner.
Email Russell to Rubenstein and others, 25 October 13, concerning meeting with Treasury/Minister's Office, re FOFA, CBA 0001 0446 0003, Exhibit 5.212.
Now, once ASIC said you've got until 1 October 2015 to stop commissions in relation to these you've got to stop grandfathered commissions in relation to transfers from super to pensions. It was then necessary for Colonial to engage with its related, or with the advisors.
Yes.
And can we bring up CBA.0001.0457.0254? So this is the sample advisor email that's to go to, I think this is really the advisor groups.
Yes.
Have you seen this before?
I've seen it in preparation.
In the course of preparing. And it explains in the key points, Colonial First State is ceasing grandfathered payments on super to pension transfers and pension consolidations that occurred during the facilitative compliance period of 19 November 2014 to 30 June 2015.
Yes.
Clients will be notified from the end of August 2015.
Yes.
And then you see there's a heading which is implications for your business.
Yes.
And it says, we understand this change may require you to re-engage with your clients, and Colonial First State is prepared to reimburse the cost of one financial consultation up to a value of $750.
Yes.
And that seems to carry with it the implication that Colonial well knows that the advisors receiving trail commission may not be in active engagement with their members.
No, my understanding of that is that the payment was because if commission was going to be used to pay for the advice, that commission would not be there, and this would enable these members to have that consultation with their advisor and agree on how their advice was going to be established going forward.
Can I suggest this, that what was plainly envisaged here was that it would be necessary for the advisor to now make contact with the client and set up some sort of ongoing fee arrangement in order to maintain revenue.
That would be necessary, yes.
And what Colonial is offering to do is to pay for that initial consultation, pay the advisor to have that initial consultation.
Well, I'm not sure if you're characterising it the way we characterised it then. But yes, we were offering to, again, this is our error, it's our misinterpretation of the law that had led to the problem, And we're wanting to make sure that our members are discussing with their advisors the way their advice relationship is going to be structured going forward.
I'm not sure I understand why you're saying this is a product of your era. Legislation has come in which prohibits the payment of commissions, yes?
Yes.
And the consequence is if a financial advisor wants to be paid money by a client, they have to enter
Yes.
into an agreement with the
Yes.
client to provide a service in exchange for
Yes.
that payment, yes?
Yes.
And the premise of this letter is you may need now to re-engage with your clients,
Yes.
because when you were getting trail commission, you weren't engaged with your clients.
I don't think that's the construction we...
And to maintain its relationship with the advisors, Colonial was prepared to reimburse the cost of that initial consultation.
That's what we thought was the best way of helping people through this period.
But it's about helping the advisor, isn't it?
Well, we thought we were helping the member by ensuring that they got advice.
But the advice that you anticipate is going to arise from this is that the member will have committed to an ongoing fee agreement with the advisor. Do you agree?
Well, that's the discussion that would take place between the member and the advisor.
And you're paying for that discussion to occur in the anticipation that that is what the advisor will be seeking.
Well, we didn't anticipate what would happen in that discussion, but yes, this is what we decided to do.
And the $750, where was it going to be funded from?
From our corporate account.
I see. Attend to that document, Commissioner.
Changes to first choice grandfathered accounts, sample advisor, email, CBA 0001 0457 0254, Exhibit 5.213. Tell me when you get to a convenient point, Mr. Hodge.
I think that's a convenient point. I say as I choke, Commissioner.
Well, if I've choked council, it is time to call it a day. 9:30 tomorrow.
Thank you, Commissioner.
Ask you to be back at 9:30 tomorrow, please.
Thank
Ms.
you.
Elkins.
All stand. The Royal Commission is now adjourned until 9:30 tomorrow. The Royal Commission is now in session.
Yes, Mr. Hodge.
Commissioner, Ms Elkins is continuing
Ms.
her evidence.
Elkins, would you be good enough to come back into the witness box, please? Thank you. Yes, Mr. Hodge.
Thank you, Commissioner. Ms Elkins, I just wanted to tidy up a few things from yesterday. Your counsel have helpfully directed the Commission to a couple of documents that were referred to by you in evidence. So you'll recall we were discussing yesterday an issue about a letter that was sent out, and you thought that there was an attachment to it that might have provided some sort of comparison. Could we bring up CBA.001.0436.5476? I'm sorry, .5478. If it helps the operator, I'm told it was these would be documents that CBA have provided this morning. Last night. So Ms Elkins, this is the covering letter, which is the same or similar to the template covering letter we were looking at yesterday.
Yes.
And if we then go to page .5480, see, this is the form that was attached to the letter for the relevant member, where all they needed to do was sign it and date it, and they would have made their investment election and they wouldn't be transferred to MySuper.
Yes.
And then if we go to page .5481, so this is then the 2-page pamphlet that was attached called What Will Happen to Your Super.
Yes.
And there's a table on the left-hand column of text, which is the difference in insurance cover and premiums estimated on 11 August 2016.
Yes.
Is that the table you were thinking of?
Yes.
And so that we can understand what this table means, it's showing that for that member, they presently hold no insurance cover.
Yes.
And if they go over into the MySuper product, the default level of cover will be $100,000 for death and $100,000 for total and permanent disability.
Yes.
And if they'd gone over, were they able to opt out of that default cover?
They would have been able to opt out of it, and they would have had to have opted out of default insurance at some time prior to being in that situation in the first place.
Okay, so they would have opted out at some earlier time under first choice.
Probably, yep.
And I just want to make sure we've understood. In terms of any comparison of the fees, if we go over to page .5482, so this is on the second page in text, we're able to see that the member would be charged $21.84 as a transaction cost for the transfer.
Yes.
Just on that, did that transaction cost arise because it was necessary to move them from one fund into another fund?
From the investment option into another. It's I'm pretty sure that's the buy-sell spread.
I'm just wondering if the member was being moved to a MySuper product within the fund.
I think that would still apply.
I see. There might still be a
That's my
buy-sell spread.
understanding. I think so, yep.
And then it then explains in text that the present estimate of annual fees and costs in first choice is $155,
Yes.
and the equivalent fees and costs would be $128.79.
Yes.
So this member is estimated to pay less fees if the member moves over into the MySuper product.
Well, it depends. The investment options are also different. Yes. 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 Well, not
Yes,
if you add back in the insurance, but yes.
They're estimated to pay less fees and costs.
Yes.
They would automatically go into an insurance premium, but they could opt out in the way that they had presumably already done.
Yes, they could do that.
All right, I tender that document, Commissioner.
What do I describe it as, Mr Hodge?
Can we describe it, Commissioner, as letter to member dated 29 April 2016 in relation to transition from first choice personal super to MySuper?
Document with that description, CBA 001004365478 is Exhibit 5.214.
And then you also gave some evidence yesterday, Ms Elkins, in relation to a cohort analysis that you thought had been performed.
Yes.
And can we bring up CBA 0001.0474.0647. So this is a template of a communication to an advisor. Is that right?
Yes,
And it's communicating to the advisor about the fact that unless the clients, certain clients, make an investment direction or give an investment direction, they will be transferred over to the MySuper product.
yes,
And we see, consistent with some of the documents that we looked at yesterday, in the second bullet point under the subject line, any impacted clients need to confirm their investment direction by 4 August to prevent their account being transferred.
yes,
And we can see from the first bullet point that the impacted clients are clients who are in first choice personal super accounts with an accrued default amount who are to be transferred over to CES, which is the MySuper product, on 11 August 2016.
yes,
And we see under the heading, why is this happening? Again, consistent with the things that we looked at yesterday, this explanation about a change to legislation requires us to hold an investment direction from investors, otherwise we must transfer their accrued default balances to a MySuper product.
yes,
And the last sentence, MySuper products do not pay commission.
yes,
And then if we go over the page to .0648, the Council for CBA have pointed out this section, which is insurance campaign.
yes.
And is this, what's explained here, what you were thinking of in relation to some cohort analysis?
Yeah, yesterday I was recalling that there was cohort analysis. Yeah,
And were you recalling that there was cohort analysis on the basis of what's written here under insurance?
insurance, yes,
I see. And so what's explained here is we will be tailoring our communications to ensure that any clients who will lose or have decreased insurance cover if their account moves to Essential Super are aware of this impact and understand that they can opt out of the transfer.
yes,
These impacted investors will receive a different version of the 90-day letter.
yes,
So your recollection is for customers whose insurance was either going to decrease or they were going to have no insurance. It's not clear why you would have no insurance, but in any event, let's assume you would have no insurance, that there would be a special letter for those identified customers.
I'm not remembering the specific details, just that there was cohort analysis.
All right, I tender that document, Commissioner.
Template communication to advisors, CBA 0001 0474 0647, Exhibit 5.215.
Thank you. Now, there's one other thing I wanted to return to from yesterday, Ms. Elkins, and that is your explanation as to why the issue had arisen at the beginning of 2014, so that Colonial breached Section 29 WA. And could you just explain to the Commissioner again why it is that Colonial wasn't in a position on the 1st of January 2014 to pay new contributions for members of First Choice Personal Super into a MySuper product?
Again, I think I am remembering or not remembering some of the detail around this, but as I remember it, the issue was that these people the members in First Choice Personal who were making contributions were thought by us to be choice members and therefore not identified as needing to be moved to a MySuper product.
I see. Now, do you recall whether it was thought that there were ADAs in the first choice personal super product?
I think there were thought to be ADAs, but they wouldn't have been due to be transitioned. Although it was before July 2017 that they. So the breach occurred because of the contributions.
Yes, perhaps if we put this in some sort of time frame, can we bring up CBA.0001.0499.0934? Can we bring up a different document? Can we bring up CBA.0001.0499.0931? Ms. Elkins, while we see if that document is able to be brought up, in your review of documents during the course of, oh, there we go. So this is a chain of internal emails. I don't suggest that you are copied to these emails, but have you reviewed them in the course of preparing to give evidence?
I'm not sure I do recall this document. I may have. I've reviewed a lot of documents.
All right. If we go to page .0933, so again, so that we can understand the timeline of what happens, this is an internal email within within CBA. And you can see in the fourth paragraph, it's dealing with first choice personal super.
Yes.
And there's an explanation that an issue has been lodged in Risk Insight. Risk Insight is the internal risk management database that CBA uses.
That's
is that
right?
And the Risk Insight issue is in relation to the ADA calculation for first choice personal super.
Yes.
And that it appears that there's been some delay in calculating and providing the information by the 31st of December.
Yes, that's what it says.
And Commissioner, can I just indicate I will tender now, but we won't be able to bring up the entry from the Risk Insight database, which is CBA.0001.0499.0934.
CBA 0001.0499.0934 Risk Insight entry concerning ADA calculation,
Yes, Commissioner.
Exhibit 5.216.
And then you see, it's also said in the email, I believe there will be a project for the transitioning of clients by 2017.
Yes.
And is that consistent with your recollection that at the end of 2017, at the end of 2013, the intention of Colonial was to move any ADAs within First Choice Personal Super over to a MySuper product in 2017?
They would just be part of the overall project for our ADAs.
But there is no more detail than
Not-
that to assess.
Not that I can't. Not that I know of.
All right. And then if we go to page .0932, you see in the middle of the page an email to Peter Chun,
Yes.
and I think he's giving evidence later today,
Yes.
and he reports to you.
Yes.
Is he responsible for product development?
He was at that time.
Okay. And it's explained to him that risk has raised an issue in risk insight as we had not identified ADAs on statements for First Choice Personal Super.
Yes, that's what it says.
Do you recall whether there was an issue which was that Colonial had not in fact put in place adequate systems to be able to identify the ADAs within First Choice Personal Super?
I do recall there were issues around identifying ADA members, yes.
And if we go to page .0931, we see at the bottom of the page an email on the 5th of December 2013, and you see the last two sentences. We are working on identifying ADAs in First Choice Personal, and this will probably be completed during first half 2014. We will then need to include the ADA in the June 2014 statements.
Yes.
Now, attend to that document, Commissioner.
Emails of November and December 2013 concerning ADA, CBA 0001 0499 0931, Exhibit 5.217.
Can I suggest to you that if you hadn't identified the ADAs within First Choice Personal Super by 1 January 2014, there was no prospect that you would be able to comply with Section 29, capital W, capital A for new contributions?
I think that follows.
And if we just step out why it follows, and the assets allocated to a member are ADAs if there is no investment direction on file.
If they derived from a default scenario, yes.
Well, there's two ways that an investment can be an ADA. Either they're just part of the default contribution,
Yep.
but also if there is no investment direction.
Direction, yeah.
And if there was no investment direction, then it would also follow that any new contributions would need to be paid into MySuper.
Yes.
And so if you haven't actually identified whether there are ADAs, you don't know whether or not there is an investment direction.
That's right, but I'm just worrying about remembering the right order in which things happen then in my evidence.
And the problem, can I suggest then, is that CBA or Colonial simply hadn't put in place adequate systems by the 1st of January 2014 to be able to comply with the law.
Well, yes.
And at least in the first half of 2014, or for most of the first half of 2014, the intention that Colonial and CBA had was that it would eventually move the ADAs towards the end of the transition period up to July 2017.
We there wasn't a date. Our intention was to go sooner than the end date.
Sooner than the 30th of June 2017.
But we didn't have an intention to leave it to the last minute, no.
If we bring up the Colonial First State MySuper transition plan, which is CBA.1004.0079.0014, and that is the transition plan dated the 1st of July 2014.
Yes?
So by this date, the issues in relation to the ongoing offences under section 29, capital W, capital A, have been identified.
Yes.
And a decision has been made that where an offence occurs and Colonial has not been able to obtain an investment direction, that it will then need to move those members over to a MySuper product.
Yes.
But otherwise, it's not going to accelerate transitioning members over to MySuper.
You mean the bulk of the rest of the ADA?
Yes.
Well, yes, that's yes.
And if we go to page .0024, we see what's described as the high-level project timeline,
Yes.
and you can see that, save for the 29 WA affected members, the rest of the transfer strategy for other members is to begin transferring them in tranches from July 2016 through to June 2017.
Yes.
Now, in settling on this timeline, was some consideration given to whether it was in the members' best interests to be in the MySuper product rather than in the product they were already in?
I would say for this timeline, this is early in the transitioning process. So I would say we were thinking about the systems build and how we would prioritise each tranche.
We understand that for ADAs in the first choice employer super,
Yes.
the analysis of Colonial is that only 9% of those members would be worse off on moving over to MySuper.
Yes.
So the other 91% would be either the same or better off moving over to MySuper.
The same, better off, or just different?
Or just different. Well, it must be either the same or better off if
Well,
it's
when
not
it comes
worse.
to the investment selection, it can be a matter of it's not better or worse off, but it is different.
It's different.
Yeah.
And I'm just trying to understand then, when you as a trustee are making a decision to approve the transitioning of members as required under legislation, how do you set in place a timeline back in 2014 without first analysing, will our members be better off the sooner they are moved over into MySuper?
Because we had to analyse a range of factors, including the system's capability and the operational risk and what else we needed to do, including getting a MySuper licence and building MySuper product and so on. So it was the holistic approach.
Well, you already would have a MySuper licence by the 1st of
By
July
then we did, yes.
2014. You had to have it
Yes,
in
that's right.
2013.
Sorry, I meant back all of the factors over time that we were looking at.
I see. So, again, I just want to make sure, in fairness to you, I've understood the points you're making. You had to obtain a MySuper licence first,
Yes.
but that had already been
Yes.
done. And then you had to do what?
Build the MySuper products,
But again, that had already been
Yes.
done. And then you had to do what?
prioritise through both the member analysis and the systems capability.
I'm not sure what that means, prioritise through member analysis and systems capability.
That we had to sequence because of the systems and operational issues that support the transfer.
I see. And so it was just going to take 2.5 years to go through and do this sequencing analysis,
Yes,
except in the case where you were committing offences and then you could get it done very quickly.
we of course were focused on resolving the breach.
Attend to that transition plan, Commissioner.
CPSL MySuper Transition Plan 1 July 14, CBA 0004 0079 0014, Exhibit 5.218.
And then you'll recall we were also looking yesterday at an email, now this was an email in July of 2014 to APRA, saying that the board had made a decision not to agree to APRA's request to accelerate the transition of ADAs over to MySuper for first choice personal super members.
Yes,
And I think you and I were both trying to find where it was that the board had made that decision, and we were looking at those minutes from April of 2014.
yes.
It seems like maybe those weren't the right minutes. Can we bring up CBA.1004.0020.1272?
What are your first 4 digits, Mr Hodge? 0014?
I'm sorry, 1004.0020.1272. That may be my...
No,
Further.
my dyslexia is cutting. Yeah, 1004.
Thank you, Commissioner. .0020.1272. So these are the minutes of a board meeting that occurred on the 3rd of June 2014.
Yes,
And you can see you were present, Ms Elkins.
yes,
And if we go over to page .1276, you see an entry which is 29 capital W, capital A compensation update.
yes,
And you can see there's a paper that's been presented by Mr. Wall and Ms. McLeod to the board.
yes,
And then if we go over the page to page .1278, I'm sorry, .1277. You see these are the continuation of the entries of what the board has done or is minuted as having done. So the first thing is it is noted that it may not be in the best interest of members with ADAs to transfer them to Commonwealth Essential Superannuation now.
yes,
And Then the next point is noted that robust processes are in place for the 60,000 members with ADAs.
Yes.
And then the third point is noted the principles and process in relation to the remediation of affected members.
Yes.
And then the fourth point is, subject to the incorporation of the requested changes, approved the changes to the trustees' MySuper transition plan giving effect to the proposed rectification process.
Yes.
And it would seem then the limits of what happened in June of 2014 was this, that management came to the board and said, APRA has requested that you accelerate the transition for 60,000 members. Management didn't, I'm sorry, that you agree that that's what that first thing happened?
Yes, I think that would.
You were aware, the trustee was aware that APRA had requested the acceleration. And in fact, to help you with that, go back to page 1276. You see the second bullet point under the item, Mr. Wall and Ms. McLeod addressed the board on the paper highlighting the proposed transition plan for accrued default amounts for affected members, including the recent suggestion by APRA that the board consider bringing forward the transition for 60,000 members.
Yes.
This suggestion has significant business implications as the original transition date is 2016.
Yes.
So what has happened is management has come and said, first, APRA has requested that you bring forward the transition.
Yes.
Second, bringing forward the transition has significant business implications.
Yes.
Do you know what those business implications were?
Again, my recollection is that related to the operational risk issues and the issues around the insurance, what the differences for some cohorts were.
That is, the differences hadn't been identified. Is that the problem at that stage?
I can't. The sequence.
You're not sure?
Yeah.
Third, management didn't present a proposed transition plan amended in the way suggested by APRA.
I'm not sure. I don't think so.
Fourth, the board then noted that it may be that it wasn't in some members' interests to transfer over to MySuper.
At that time. Not to bring it forward.
And fifth, therefore, said we'll stick with management's plan.
Well, I think we would have, the board would have realised that this would be subject to ongoing consideration, not just we'll stick to the plan.
And why would it not be in members' best interests to transfer them in 2014, but it would be in their best interests to transfer them in 2016?
I believe that referred to if there were operational risks and something went wrong, if there were problems with the transfer, or for those cohorts that had been identified that we wanted to contact to make sure they understood the insurance arrangements.
Was one of the issues of which you were aware that immediately moving these ADAs over to MySuper would affect the relationship between Colonial and its advisors?
I don't recall the board ever discussing that.
You don't recall the board ever discussing that? No, but was one of the issues of which you were aware, because you were an executive,
Yes.
that if there was an immediate movement or an immediate transfer from ADAs over to MySuper, that it would affect the relationship between Colonial and its advisors?
Yes.
That was something that you were aware of?
Well, I was aware that advisors were impacted by this, yes.
And that was a matter of concern to management?
We were aware of it. I don't know that it follows it would affect our relationship with the advisors, but we were aware that advisors were concerned, yes.
And that was why you were taking active steps for the benefit of advisors to obtain investment directions from members?
We were taking active steps to ensure the members had information to assist them with the choices they had.
What I want to put to you is, we've seen many communications now that the active steps that were being taken by Colonial were to obtain investment directions from the members.
Yes.
And the purpose of obtaining those investment directions, or a purpose, I'm sorry, for obtaining those investment directions was to benefit advisors.
That wasn't the purpose.
That was a purpose.
It. Or yes?
Commissioner, I think I may have already tendered that document.
The minutes of 3 June 14,
Yes.
I'm not conscious of it.
I
Having-
tender that document then, Commissioner.
CBA 1004 0020 1272, minutes CFS Investments Limited 3 June 14, Exhibit 5.219.
Ms Elkins, I want to move to another topic, which is cash returns. You're aware that earlier in the year there were some newspaper articles, or at least a newspaper article published in the Australian concerning cash returns,
Yes.
and that raised questions as to why the returns of certain bank-linked retail funds were so low.
Yes.
And that prompted a fair bit of internal communication within Colonial and CBA.
Yes.
And is it fair to say Colonial and CBA were unhappy with the article?
Yes.
And can we bring up CBA.0001.0421.2819? One of the points made in the article in the Australian about CBA Super's cash returns was the difference in 12-month return between various cash options.
Yes.
And as we understand it, the internal analysis of CBA is that the entire explanation for the difference between the different Colonial products is fees.
Yes.
And so in the case of the Colonial First State cash option, which forms part of the first choice pension, the 12-month return is only 1.19%.
Yes.
And then for the Colonial First State wholesale cash option within the first choice wholesale pension, the 12-month return is 1.9%.
Yes.
And for Group Super, the 12-month return is 2.01%.
Yes.
And we can see there's a table here where there's a column in the middle which is percentage-based fee.
Yes.
And this is setting out what the percentage-based fee is for each of those cash products.
Yes.
And the 1.14% fee, which is being charged on the cash option in first choice pension, that includes a trailing commission.
Yes.
And the trailing commission is 60 basis points.
Yes.
And is that, from the perspective of Colonial, the significant, the only explanation for the lower performance of Colonial First State cash within first choice pension, that there's a trailing commission?
Yes, I believe so.
And once this was identified, prompted by the newspaper article, did that then lead to the next obvious question, which is, why are we paying a trailing commission on cash?
That, you know, as I said yesterday, all of our arrangements are under review.
I tender that document, Commissioner.
Summary of page 1 article, The Australian, 11 June 18, CBA 0001 0421 2819, Exhibit 5.220.
And then I want to move to another topic. Oh, I'm sorry, actually, before we do that, when you said the question is under consideration, is it under consideration by Colonial First State as trustee, or is it under consideration by some other part of the bank?
In our corporate capacity, it's under consideration.
I see. And there's something called the Product Governance
Yes.
Forum. Are you on the Product Governance Forum or part of the Product Governance Forum?
I don't think I am on the forum. I think it reports to me.
It reports to you, did you say?
Yes, that would.
Is it Mr. Chun who runs the Product Governance Forum?
No, not any. He would have in his previous role.
I see. I'll just bring up for you a document which is CBA.001.0450.0161. So this is the minutes of a meeting of the Colonial First State Product Governance Forum. The meeting is meeting number 1 on the 21st of June 2018.
Yes,
So the forum has just been established.
there was a previous forum. This has been re-engineered, if you like, or yeah.
And who is Kelly Power?
She is the head of product.
Does she report to
She
you?
does.
All right. So do all of these people listed here report either directly to you or indirectly to you?
No, they don't. So do you want me to go
Yes,
through it?
please.
So Brendan French is the CBA customer advocate. Linda Fox is the CFO for Colonial. She does not report directly to me. Franca de Blasio is the line 2 risk person responsible for Colonial and does not report to me. Todd Stevenson reports to me. He's in a customer and marketing role. Peter Chun is now in a distribution role and reports to me. Kylie Turner reports to Kelly Power. He's a product specialist. Same for Dave Yates. Jeff Ferris is in our customer operations team.
That's customer operations within Colonial
Yes,
First State. So
reports
ultimately
to somebody who reports to me. Sue Wallace is in the wrap business in Melbourne as a product specialist.
Again, within the business that
Yes.
reports to you.
Same for Deb Taylor. Peter Labrie is a product specialist. Lisa Rava is legal, does not report to me. Dale Hawkins is in a wealth management, I'm not actually sure what the title is, but does not report to me. And Marissa Wallace, I'm not sure.
And then there are some apologies, one of whom is you,
It's me, yes.
and then Scott Henricks
Operations,
and Bronwyn Edel. Or Edel.
I think Bronwyn might be in risk, I'm not sure. Nick
Right.
Clements is risk.
In any event, this is a forum comprised of a number of people who
people don't.
report either
Yeah.
directly or indirectly to you,
Correct,
and also some people from customer relations,
yes.
and also
Customer
some people
advocate.
I'm sorry,
From the customer advocate.
from the customer advocate,
Mhm.
and also some people from risk,
Yes,
which is
and legal, yes.
and legal, and
Which-
that's separate and
Yes.
outside of what reports to you.
Yes,
And you see recommendation number 3 is in relation to contribution fees,
yes,
and the decision sought by seemingly from the forum is endorse removing contribution fees for all members in a phased approach.
yes.
Can you just explain to the Commissioner what a contribution fee is for colonial products?
There are some legacy products that used to have, that have a fee that is deducted when contributions come in.
So, for example, every new contribution, 4 or 5% of it might be deducted
Yes,
and paid to the advisor.
yes, it's a commission.
When it paid as commission to the
Yes.
advisor, and when it gets, I'm sorry, and it's deducted whether or not there's a linked advisor.
I don't know the answer to that. I think only when I'm not sure. Yeah, I'm not sure, I'm sorry.
When the fee is ultimately paid over to an advisor,
Yep.
even if that advisor is external to the CBA group, is there still some part of the fee that flows to CBA or Colonial?
I'm sorry, I don't know the answer to that.
Okay. And so the Product Governance Forum is endorsing the recommendation to remove contribution fees. Has the board of Colonial First State, in its capacity as trustee, ever considered removing contribution fees?
I don't think that recommendation, the board is aware of these reviews that are going on. I'm not sure process-wise whether this has, I don't think so, because off the back of this recommendation, we are investigating moving forward with this, and we are currently seeking legal advice.
As to whether you can remove contribution fee. And then you see recommendation number 4, management fees. And the decision sought is endorse reducing the management fees in NEF. What is NEF?
Nil entry fee.
To entry fee.
Yeah, that's right. Yep.
And further reducing entry fee options to first choice personal.
Yes.
So could you just explain to the Commissioner what is the decision that's being considered here?
To look at reducing our fees.
To reduce the management fees for nil entry fee products, is that right? Is it
That or both.
Is it perhaps this, that you have lower management fees for entry fee products than you do for nil entry fee products, and you're considering reducing the management fees for nil entry fee products to the level of entry fee products?
And further reducing the entry fee. So I think we're looking at fee reductions, as I said yesterday, across the board.
I see. And then you see the third bullet point under that is noted by Ms. Power that CBA's strategic position in relation to Trail Commission will need to be determined, including an understanding of the impact to aligned dealer groups.
Yes.
Now, you weren't there at that meeting, but do you know what that means?
I take that to mean what I've already been talking about, that this is part of the broader consideration of commissions that is underway.
It would seem to suggest that the decision as to whether or not to remove trail commissions depends upon a decision by CBA as to the strategic position it wants to take with respect to trail commissions.
I don't think it means it depends on it. I think it means all of these things are currently under consideration.
Is there any sensible possibility that Colonial First State as trustee would decide to remove trail commissions without its owner, CBA, having made a strategic decision to give up trail commissions?
I don't think I can answer that. I don't.
Well, you sit on the board of the trustee and you have sat on it for a number of years.
Yes.
You've given evidence in your statement as to consideration in relation to trail commission. So it seems as if you must be able to express a view, at least from your perspective. I appreciate one of the difficulties you perhaps face in answering this question is that you're wearing many hats, as we've already talked
Yes.
about. From your perspective,
Yeah.
is there any sensible possibility that you, as a director of Colonial First State, in its capacity as trustee, would move in favour of removing trail commissions if that was not the agreed position of CBA?
That could definitely happen.
And is it something that's come up before now?
No.
Okay. But you think it's possible that
Possible.
maybe the trustee might do it?
Possible?
And this reference to CBA's strategic position in relation to trail commission will need to be determined. Is that your view, that CBA's strategic position in relation to trail commission will need to be determined?
I think my view is that CBA is considering that position.
Yes, you see, what this is stating, at least in the literal words on the page, is that CBA's strategic position in relation to trail commission will need to be determined, suggesting that what is going to happen with the products will depend upon what strategic position CBA wants to take.
I can see that that's what that says.
And is that your understanding of the reality of the situation?
I'm not sure. That's going to come out as we go through the work. I can't answer definitively one way or the other. No, I don't think it is.
Colonial First State is effectively the product manufacturer.
Yes.
CBA has the related dealer groups.
Yes.
Is Colonial First State presently waiting to hear from CBA as to what CBA's position is as to trail commission?
No. We're aware that they are considering that.
I see. You're aware, the product manufacturer is aware that that is being considered by CBA,
Yes.
and you're expecting at some stage that CBA will tell you what its position is,
I would expect they would, yep.
and then Colonial First State will do whatever follows from that position.
Well, I think that there's things happening in parallel, a number of things happening in parallel.
What is happening in parallel within Colonial First State?
We're looking at these product reviews, we're seeking legal advice, there's broader work going on.
You're determining whether it's possible for you to simply terminate trail commission.
Yes.
I tender that document, Commissioner.
Minutes of CFS Product Governance Forum, 21 June 18, CBA 0001 0450 0161, Exhibit 5.221. Can I ask whether the date of that forum, how does that relate to CBA's announcement of intention to spin out certain parts of its business?
I don't think there's any relationship,
No,
Commissioner.
I'm just asking you the date, the temporal
sorry, the date,
relationship. I'm not asking other
yeah, sorry.
connections.
The date, I think CBA had made the I couldn't be sure. The announcement is in my witness statements.
It's a month after
Month after the announcement.
I'm not sure whether it was before 21st of June.
Commissioner, I'm helpfully told by our friends that it's about a month afterwards. That is, the product forum is occurring about a month after the
A month
announcement.
after the announcement of the spin out. Yes, thank you.
Oh, now they're being told that's wrong, so in a moment I'll be told that's wrong.
Paragraph what?
The forum was the 21st of June.
Yeah.
The announcement, 25th of
It'll be a matter of public record and we can track it through ASX announcements, but I just thought somebody might know. I should know and I don't.
It's, in fact, the forum occurs on the 21st of June and the public announcement is on the 25th of June 2018.
Thank you.
Ms Elkins, I want to move now to a topic concerning dealings with related parties.
Yes.
And we might start with investment management fees. I can show you a document if this will help to orient you. What we'd like to understand is the process by which CBA goes about determining or negotiating its investment management fees with its related party.
Yes.
Can I bring up CBA.1004.0027.6811? So this is a minute of the meeting of the Board of Directors of Colonial First State on the 24th of February 2017.
Yes, I believe I was not on the board at that time. I see I'm an attendee, but I suspect I was not.
Oh, I see. You may not have attended for the entirety of the meeting.
I'm not sure, and I wasn't a board member.
Okay. Was the situation that you had been a board member, then you
Before.
stepped off the board,
Yeah,
and then you
back
became
on.
a director again?
Yes.
Okay. And are you able to just to help the Commission understand why it was that you stepped off and then stepped back on?
I was on secondment
I see.
elsewhere in CBA.
And if we go to page .6812, you'll see there's an item at the top of the page which is about the operating model or fee review with Colonial First State Asset Management Australia Limited.
Yes.
And I think you may have given some evidence in your statement about the process of who manages what assets.
Yes, I think so.
And is the situation that Colonial First State as trustee has invested the money into a managed investment scheme of which Colonial First State is the responsible entity? That's the first step.
Yes.
And then those assets are then managed or invested by, I think there might be two companies, but one of them is Colonial First Asset Management Australia Limited.
Yes.
And does it manage the assets by itself operating further managed investment schemes?
It can do.
Okay.
It depends.
And Colonial First Asset Management Australia Limited, is that a wholly owned subsidiary of Colonial First State?
No, of the Commonwealth Bank.
Of the what, sorry?
Of Commonwealth Bank.
Okay. Does it have a separate management team?
Yes.
And so when a negotiation has to happen over the fees that will be paid by Colonial First State Investments Limited to Colonial First State Asset Management,
Yes.
that occurs between whom?
The two business teams.
So they,
So they would have their team, we would have our team.
and then you'd negotiate over how much is going to be paid, is that right?
Yes.
And it seems that there was some change so that distribution and marketing was being moved
Yes,
over. Could you
that's
just
right.
explain what that change was?
I'm going to have to remember, I think it's that simple, that distribution and marketing for the investment options used to reside in Colonial First State, and that was moved from Colonial First State across to GAM, across to their business, yeah.
And can we put that document on one side of the screen, and on the other side of the screen bring up CBA.1004.0027.6292? Thank you. So this is I know that is not the correct document. we'll try a different doc ID. Can we try CBA.1004.0027.6292_E? Or CBA.1004.0027.6304_E. Thank you. So you see, this is the paper to the board reporting on the investment management fee negotiations.
Yes.
Now, do I understand you to be saying at this time you would have been on secondment away from Colonial First State?
During this time, I've forgotten the start date of that, but it was sorry, I have forgotten it. I can look it up if you like.
That's all right.
But yes, during this time, for most of this time, I was on secondment.
Okay, but you continued in some respect in your role as Executive General
Not at all.
Manager? No, you were out of...
I was out.
Okay. But some people within the team that you had been responsible for and are now again responsible
Yes.
for were negotiating with Colonial First State Asset Management
Yes.
about the investment management fees that would be payable.
Yes.
And it would seem that the board doesn't need to sign off on an agreement. It's just necessary. This is just reporting to the board for the board to note.
Right.
Is that your understanding?
Yes.
And you see there's a reference in 3.2.1 to engaging a third-party consultant, Chant West, to provide an investment fee benchmarking report.
Yes.
And then if we go to page .6307, we see this is setting out what the proposed investment management and distribution fees are to be.
Yes.
What we're just trying to understand is if you look at those various CFS GAM funds, you see there's a column which is current investment management fee,
Yes.
which is for investment only,
Yes.
and then proposed investment management fee, which is to include distribution and marketing.
Yes.
And then there's a Chant West benchmarking range. Can you see that over on the right-hand side of the
Oh, sorry.
page?
Yes.
And it looks to us like for every product except CFS Future Leaders and CFS DevCo, that at least what had been the investment management fee was outside of the benchmarking range.
Yes.
And depending on what value you ascribe to the marketing and distribution, it might now be moving within the benchmark range, although it might still be outside the benchmarking range.
Yes.
And what we're trying to understand is, does this suggest anything about the adequacy of... I'm sorry, and just so that you are to be fair to you, can I just also point out on the next page, which is .6308, you'll see there's the double asterisk includes embedded cost of distribution and marketing estimated to be approximately 0.1% to 0.15%.
Yes.
So what we're just trying to understand is if the investment management fees before this change to include distribution and marketing were all outside of the benchmark range, does that suggest anything to you about the adequacy of supposedly arm's length negotiations between two teams within CBA?
Well, I think it suggests that this negotiation needed to happen this negotiation is relating to incumbent positions. These are not new positions. These were the need to revise the incumbent places that they had. So yes, it shows that it was necessary to do the negotiation, yes.
I see. I tend to that document, Commissioner.
And
and the minutes.
the minutes of the board, CFS Investments 24 February 17, CBA 1004 0027 6811, Exhibit 5.222, Board Paper 24 February 17 concerning investment management fee negotiations, CBA 1004 0027 6304 _E, Exhibit 5.223.
Now then, the other related party dealing I wanted to ask you about was insurance.
Yes.
The Colonial First State funds use CommonSure as the provider of group insurance.
Yes.
And can we bring up CBA.0001.0430.0831? This is an insurance benchmarking review conducted by Rice Warner for Colonial First State.
Yes.
Is there a negotiation that occurs between some team within Colonial First State and a team within ComInsure over the insurance premiums?
So in line with our investment insurance governance framework, there's an annual review of the insurer.
And how does the annual review work? How does it affect the premiums?
So, there's two ways premiums may get negotiated. It could be part of the annual review, but it's also an expectation of the relevant product manager in terms of maintaining the insurance product. So it doesn't have to be at this annual review.
The annual review, does that involve ComInsure saying what premiums it proposes to charge?
The annual review is the holistic review of the insurer. So there'll be a date by which in our agreements that premiums are due to be negotiated. This review is part of our prudential standards to review our insurer annually. And this benchmarking will serve two purposes. One is as part of the annual review. The other is it arms the product managers with information for their ongoing relationship with the insurer.
Now, in terms of the breakdown of members of the CES product, which is what this benchmarking review concerns, that is Commonwealth Essential Super. Are most members blue-collar workers or white-collar workers?
I don't know off the top of my head.
Okay. If we go to page .0836 of the review, you see there's a section which is pricing.
Yes.
And there's a heading for death only.
Yes.
And it said CES, so that's Commonwealth Essential Super, is competitive against the peer group for blue-collar occupations and smokers for some ages. And then there's in brackets, given CES premium rates don't use occupation type and smoker status as rating factors.
Yes.
So does that mean that ComInsure, unlike other insurers, isn't charging a differentiated premium depending upon whether or not the worker is blue collar or white collar, and isn't charging a differentiated premium depending upon whether the worker is a smoker or not?
I think that's right. Actually, I think that's right, yes.
And then you'll see the next point is CES premium rates are uncompetitive for white-collar workers compared to the median price of the peer group, especially for females aged between 30 and 50 next birthday.
Yes.
And then you see that's just for death only, but then there's also some commentary in relation to death and TPD cover.
Yes.
And there's one respect, it would seem, in which CES is cheaper than the median price, which is blue-collar workers aged under 35. And it said rates for white-collar workers are generally uncompetitive,
Yes.
but especially for ages over 35.
Yes.
And white-collar occupations and smokers are disadvantaged by CES having no smoker or occupation rating factors applied.
Yes.
The conclusion, though, perhaps of comfort to the board, is our key you can see this at the bottom of the page. Our key conclusions from this analysis.
Take the pop-up down, please, and just have the page.
Our key conclusions from this analysis is that CES has a package of death, TPD, and income protection features that is competitive with peer group of products.
Yes.
That seems to be saying it's competitive in terms of features. It doesn't suggest it's competitive in terms of pricing.
I don't know if that's what that means.
And this is a report that gets taken to the board,
Yes, I believe this did go to the board. Yes.
and the board gets one of these every year, is that right?
I don't know if they do the benchmarking every year. Yeah, I'm not sure how often they do the benchmarking.
If there is a benchmarking, then it goes to the board.
It would, yes.
And each year the board has continued with ComInsure.
Yes.
If we go to page .0841, so this is a table setting out the competitiveness of CES for death-only cover,
Yes.
and it's compared to a peer group of 8 products.
Yes.
So the worst ranking that you can get is 9.
Yes.
And you see, if you look at that table, that there is really, there are only a few occasions in respect of which ComInsure does better than 5,
Yes.
and only one occasion in respect of which it's the least expensive premium, which is a female smoker blue collar, aged 20 to 25.
Yes.
But you see, perhaps of more significance, that there's an analysis of the results which shows that CES's non-smoker rates are on average 34% more expensive than the median of the peer group.
Yes.
White-collar non-smoker rates are 61% more expensive than the median of the peer group.
Yes.
Blue-collar non-smoker rates are 19% more expensive than the median.
Yes.
And for blue-collar workers, CES is ranked cheaper compared to the peer group for some ages, You see that in the fourth bullet point.
Yes.
But across gender, smoker status and age, blue-collar CES pricing is on average 11% more expensive than the median price.
Yes.
And then if we go over the page to dot 0842, now we see the same type of table, but this time for death and TPD cover.
Yes.
Again, though, for a $250,000 sum insured.
Yes.
And we can see that the performance of CES is still very poor for white-collar workers. Do you agree? It's very poor for white-collar workers.
Yes.
And then it's either in the middle or up to 3 or 4, and on a couple of occasions, or on a handful of occasions, 2 for blue-collar workers.
Yes.
But if we then go to page .0860, this is a table that shows a different type of breakdown, this time not based on the ranking amongst the 8 competitors, but how the premiums compare percentage-wise to the median.
Yes.
And so that you can see that, to take the most extreme example, for a female non-smoker white-collar worker aged 41 to 45, the premium is 132% higher than the median.
Yes.
And I should note, the best comparison to the median is for a female blue-collar smoker aged 20 to 25, when the premium will be 29% under the median.
Yes.
And what I want to suggest to you is, looked at on the whole, when ComInsure does worse than the median, it does much worse than the median.
Yes.
And when ComInsure does better than the median, it does only a little bit better than the median.
Yes.
And we see the same type of pattern play out if we go to page .0861. And we can see again, it does in certain respects, and in one respect particularly, for a female blue-collar smoker aged 20 to 25, do better than the median.
Yes.
But certainly for white-collar workers, it does much worse than the median.
Yes.
And I tender that document, Commissioner.
Price Water Insurance Benchmarking Review, 11 April 17, CBA 0001 0430 0831, Exhibit 5.224.
Do you think there are any conclusions that the Commission can draw based on that report as to the adequacy of the supposedly arm's length negotiations between Colonial First State and ComInsure?
Not necessarily. I think the role of the product manager is to do the benchmarking, do the annual reviews. That's overseen by the Office of the Trustee as well. Then to come to a conclusion as to whether we're better off. Again, this is a position of incumbency, So the question becomes, are we better off to negotiate with the incumbent insurer where we see these weaknesses, or are we better off to change insurer? And on balance, the decision that's been made is to negotiate with the incumbent insurer. But this benchmarking would inform that negotiation.
Can you ever recall any serious discussion at board level about the possibility that Colonial would cease to use ComInsure as its insurer?
Yes, that has been discussed.
And when has it been discussed?
On and off, on different occasions it's been discussed.
Recently?
I think it was discussed. Again, it was a discussion. I know it's not minuted in relation to, as I said, because this was a decision, are we continuing with the incumbent? What's the alternatives? And of course, the sale to AIA had also occurred, and that was also informing our view to continue.
We can take that down. We're going to move to another document, Commissioner. Now, Ms. Elkins, I think you told me this yesterday, but AIL, are you also a director of that company?
Yes,
And AIL has, in the last couple of months, given a notification of breach to ASIC,
yes,
and that notification of breach concerns AIL continuing to charge advisor service fees to members who had died.
yes.
And I was just trying to find the breach. I think actually, to be fair to you, AIL gave a notification to both ASIC and to APRA,
Yes,
and you've exhibited those notifications to your statement.
yes.
And was the way in which I withdraw that, I'll put it a different way. As you know, there was an issue that arose during round 2 of the Royal Commission, or the second round of hearings of the Royal Commission, concerning advisor service fees being charged to people who had passed away.
Yes,
And as a result of that, did CBA and Colonial put in place a program of work to check whether that was happening in other areas?
to check whether it was happening at all, yes.
The issue that had been identified in round 2 was in relation to certain individual advisors charging fees to dead clients.
Yes, it was advisor service fees that were identified in round 2, yes.
The issue that was identified, or has since been identified by AIL, is that where it had been notified that a member had died, it had continued to charge advisor service fees.
That's right.
And the fact that it was doing so had first been discovered back in 2015
Yes,
and identified as an issue that required an update to the product disclosure in 2015.
yes,
That is, what AIL thought that it should do is, in the product disclosure statement, say we will continue to charge advisor service fees after the member has died.
yes,
But it hadn't done so.
correct.
And so it formed the view, when it's reviewed the issue this year, and in fact it had formed the view, I think, to be fair, back in 2015,
Yes,
2016, that if it wasn't telling members that when they died it was going to continue to charge them advisor service fees, that it shouldn't have been doing so.
that was in 2015, and on this review, the conclusion we made was that the practice should cease and should never have occurred.
I see. I understand. You're saying in 2015 and 2016, the view wasn't that it shouldn't be done. The view was that it needed to be notified to the members. But in 2018, the view is it shouldn't be done.
That's right.
And
And our view is that in 2015, the view should have been that it shouldn't be done.
it should have been realised in 2015.
That's right. Yes.
And do you know why it wasn't realised in 2015?
No, and we do have, we have asked Deloitte to assist us to investigate that so we can understand it.
Was it only AIL that has this problem?
Yes.
So it's been looked at within Colonial and the problem hasn't been identified in Colonial.
That's right. There's ongoing work going. We're reviewing all of our processes in relation to deceased estates to see if there are any other issues at all, but certainly this issue, we cease the fees upon notification of death in CIPSL.
I want to show you a document which you may or may not have seen before. Can we bring up CBA.0001.0435.1742? So this is an internal presentation from Colonial First State on advisor service fees and payments.
Yes.
And you see it's dated the 2nd of November 2016.
Yes.
Is this a presentation that you'd seen before
No.
preparing to give evidence?
No.
Did you review it in the course of preparing to give evidence?
I think I did.
Okay. Are you able to help us as to who the presentation would have been directed to?
No.
Okay. Can we go to page .1743? So this is seemingly explaining the then approach of Colonial First State to advisor service fees. Could I just ask, you see the reference to LSF. What does LSF stand for?
Licensee service fee. It's a form of ASF.
Okay. So all entities regard advisor service fees and licensee service fees as an expense requested by the member, not a fee for the purposes of our services or obligations. You see that first
I
point?
see that. I'm not sure I know what that means.
And then the last point is we do not require or intend to require licensees to provide positive confirmation of ongoing services.
Yeah, well, that's just incorrect.
Is that a position that's changed?
There was always the advisors who work with us sign up to our dealer terms of trade and are required to notify us of any failure to provide ongoing service.
They have to notify you if they fail to provide
They
service?
have to notify us if they fail to provide, and since then we are in the process of implementing further testing that we do as well, yes.
And again, you said this statement is just wrong. This seems to be saying you don't require licensees
Oh, I guess
to
you're
provide
right. It says positive. Okay, yes.
So that is correct.
That's correct, although not necessarily, because in any case where we investigate, we would require them to provide that positive attestation.
And then if we go to page .1744, so this is outlining the different obligations of the entities, and we can see the RSE is Colonial First State Investments Limited and AIL.
Yes.
And it's explained at the bottom, the request for these entities to support these fee arrangements are considered an expense of each respective entity.
Yes.
So, as we understand it, the approach of Colonial First State is that the advisor service fee is an expense incurred by Colonial First State as trustee and therefore something that it can deduct from the member's account? Or you're not sure?
Yeah, I'm not sure technically of what the word expense means there. The fees are agreed between the advisor and the member, and then the member authorises us to deduct the fee.
And then if we go to page .1747, So this is explaining what the existing fees and caps are. And you see that there's the first item, which is initial advice fee up to 4.1%.
Yes?
That is different, as we understand it, from a contribution fee.
Yes.
Okay. The contribution fee is a commission that
Yes.
would keep being paid
Yes.
for every contribution.
Yes.
And then if we go to page .1748,
By the way,
oh, I'm
there's,
sorry.
no, it doesn't matter. There's inaccuracies in that table, but
Oh,
it doesn't matter.
No, let's go back to 1747. What were the inaccuracies?
The ASF and LSF's no limits. There are limits.
There's a
I think there's a
2% limit now, is that
Yes.
right? Would there have been a 2% limit as at November 2016?
I guess probably not, because they did this presentation.
And then if we go to page .1748, you see this is a list of what the existing controls are.
Yes.
And there's a reference here to monthly advisor fee monitoring.
Yes.
Are you able to explain to the Commissioner what that is?
So that is, and then let's see the next one, the spot fire monitoring. That is, first of all, that we run a test for the cap that we just talked about, the 2% cap. So looking for any fees that are over that, which triggers an investigation. And then the spot fire monitoring, as I understand it, and it is something that is under review and being enhanced, is where we're looking for certain triggers that would cause us to investigate, to seek the positive attestation about the fee.
Right. And then if we go over the page to .1749, this is identifying known gaps. And
Yes.
the first one is fees are not removed retrospectively if the member complains.
Yes, I believe that's been rectified.
So now if a member complains about their advisor service fees, they'll be refunded back the advisor service fees.
I think that's right. Sorry, I probably
Not
should.
certain.
I'm not certain, but I think so, yeah.
And then you see current practice, but a consideration given the recent ASIC report. And the first item is no positive confirmation of continued services.
Yes, so this is talking about, again, we have that program of work underway to look at, given the ASIC fee for no service report, what more we should be doing to seek assurance that the services are being provided.
And this would be, for example, requiring the advisor to provide an attestation that they've
That's what we're
provided
working
services.
through is what form that's going to take. Yes, it could be changing from the reporting to attestation. It could, that's right. We haven't landed, we're seeking improvements where we can make them, like enhancing the spot fire early warning and some other measures, and looking at what overall can we do.
Would presumably affect your relationship with your advisors if you start requiring them to provide attestations.
So be it, yes it will. To be honest, the advisors, we've had advisors who have been very helpful. They obviously also are aware of the ASIC report, and advisors are working with us to look at how that can be provided.
And you see then the next point is advisor service fees post-death of the member. We currently continue to pay but are looking to put controls in place after, say, 3 months.
So that is in reference to AIL. That was not occurring in CIFSL.
It was only occurring in AIL.
Yes.
And was a control ever put in place for the fees to stop after 3 months?
No, there was a. We can see that there was that this was, there was an attempt, if you like, or some business rules around this, but I don't believe they were effective.
Attend to that document, Commissioner.
CFS, advisor service fees and payments presentation 2 November 16, CBA 0001 0435 1742, Exhibit 5.225.
Now then, if a member dies, they may have trailing commission being paid in respect of their investments to an advisor?
Yes.
And
Sorry, I had to just think that through. Yes.
that's right. And as we understand it, because of FOFA, if there's no reversionary beneficiary, then the grandfathered commission will have to cease.
Yes.
But if the member has named a reversionary beneficiary, then...
Prior to July 13.
I'm sorry, prior to July
If
2013.
the reversionary beneficiary was nominated prior,
To July 2013. Or 2014 would it be?
I'm not
You're
sure.
not sure?
Yeah, one or the other.
Prior to some date.
Yes.
Then the grandfathered commission can and does continue, is
Yes.
that right? And again, has Colonial First State given any consideration to specifically stopping commission being paid out of the assets of a deceased member?
It would be in the overall review that I've already spoken to you about.
Now I want to move to one last topic, which is the enforceable undertaking that was given recently to ASIC in relation to the selling of CES in the branches.
Yes.
Now, Mr. Chun, who's the next witness, is going to give evidence, as we understand it, in relation to the selling of CES in the branches.
Yes.
But you were copied on a number of emails
Yes, I was.
as the enforceable undertaking was negotiated.
Yes, I was.
And I just want to ask you about some of those documents.
Yes.
So as we understand it, and I'll just outline this very briefly to make sure we agree with about this in summary. In about 2012, Colonial First State and CBA started developing a program whereby Colonial First State would establish a super fund and CBA would sell that super fund in its branches.
Yes.
And that super fund was CES.
Yes.
And then by the end of 2014, it had become apparent, or at least become apparent to ASIC, but probably also to CBA and Colonial, that there were issues about the way in which that was being sold in branches.
Yes.
And in particular, the linking of a financial health check to the sale of the super product.
In 2014, I don't think we knew that that was the issue.
I see. Just that there
Actually,
were...
I'm not even sure the financial health check was in the branch at that time.
I see. In any event, at some
That
point it
ASIC were
became apparent
investigating, yes.
that there was an issue, which was that this looked a lot like personal financial advice.
That was the issue that emerged, yes.
And towards the end of 2016 or early 2017, ASIC had suggested to Colonial First State and to CBA that it was going to commence a proceeding in a court.
Yes.
And Colonial First State and CBA's position was that rather than commencing a proceeding in a court, ASIC should, I don't think I'm being unfair in saying this, put out a media release.
Yes.
And ultimately, you met somewhere in the middle. ASIC no doubt put out a media release, but also you entered into an enforceable undertaking.
Yes.
And
Well, CBA did. So
CBA
I
did.
do want to be careful not to represent CBA's
Yes.
view rather than my own view of what happened.
And I just want to pick up the process or some aspects of the process by which the enforceable undertaking came about. So can we bring up CBA.0001.0478.0058? So this is an internal email within CBA sent by Larissa Shafir to a number of people, including Mr. Coleman, Ms. Spring, Mr. Cohen, you, Ms. Lamarck. You see that?
Yes, I actually can't read that very well.
Well, if we look at the attachment to it, and we go to page .0064.
I can't, if it matters, I can't read
That's right. I
that.
think we can take the.
Okay.
We'll be able to look at the document afterwards. Oh, apparently that's in as a different document. It's CBA.0001.0478.0064. So this is the letter from ASIC to Ms. Shafir, and it's, if we go to page .0065, we see this is ASIC making a proposal which is for the matter to be resolved on the basis of an enforceable undertaking.
Yes?
And you'll see in the preceding paragraph it says ASIC remains open to resolving the matter outside of court.
Yes?
And again, just so we can make sure that we've understood the context of this, ASIC has previously said it wants to, or it's going to commence a court proceeding.
I'm not sure about that, sorry, Mr.
It at least
Hodge.
raised the possibility of a
Yes,
court proceeding.
yes.
Okay. And now it said it's prepared to resolve the matter on the basis of an enforceable undertaking.
Yes?
Okay. I tender the email together with its attachment, Commissioner.
Emails concerning ASIC letter about Essential Super, Shafir, Coleman and others, together with attached letter ASIC to Shafir, CBA 27 July 17, CBA 000104780064 is the attachment. The email is CBA 000104780058. Together will be Exhibit 5.226.
And then if we bring up CBA.0001.0479.1381. Maybe if we blow up the top so that we can
Yeah.
see first who the email is to. So you see this is an email from Ms. Shafir to a number of people, including Mr. Coleman, Ms. Spring, you, Mr. Sullivan, Mr. Cohen, Ms. Larnack.
Yes?
And then if we take that down and then blow up, there's a section about a quarter of the way down the page which begins, I understand that the preferred approach is. And so if we just look at that paragraph plus the next paragraph, right, so what is explained is that the preferred approach
Yes.
of CBA is to resolve the matter without an EU if possible
Yes.
and subject to a media release.
Yes.
And irrespective of whether the resolution is by way of EU or media release only, negotiate the terms of the undertaking so that it permits RBS Wealth Management to move forward with Project Everest.
Yes.
Are you able to explain to the Commissioner what Project Everest is?
So Project Everest, amongst other things, but the bit of it that was relevant to Essential Super was to look at how we could respond to the concerns that ASIC had raised and ensure that we were, if we put Essential Super back into the branches, that it was under a general advice model without the risk of straying into the personal advice territory. So it was, how do we do this in line with what ASIC requires?
And then if we blow up the next paragraph, we see the steps that are proposed are that Matt Coman will call Peter Kell in the next few days to confirm willingness to engage on a no EU basis.
Yes, and could I just remind you that Matt would have been in his role as Group Exec of Retail Bank at that time, not the CEO.
Yes, he wasn't the CEO
No,
at
he
that
wasn't.
stage. This was not happening at the CEO level.
That's correct.
It was happening below the CEO level.
Yes.
And if Peter Kell indicates willingness to entertain the no EU approach, then ring Tim Mullally later this week to request a meeting to agree on way forward.
Yes.
If not, write to ASIC on 18 August accepting the EU in principle but seeking to discuss specific terms of the undertaking.
Yes.
And then in either case to seek clarification.
Yes.
And if we take that down and then blow up, there's a heading which is no EU position. And I just want to blow up the sentence under that. And this is the view of Ms. Shafir. On balance, it is unlikely that ASIC will want to resolve this matter other than by way of an EU.
Yes.
And just so we can understand how a bank like CBA goes about dealing or negotiating with ASIC, this email suggests first that CBA knows by this stage that ASIC is unlikely to be willing to resolve it other than on the basis of an EU.
Yes.
Second, ASIC has already sent a letter with respect to which this email is dealing, proposing an EU.
Yes.
Third, CBA is in fact willing to resolve this by entering into an EU.
Yes.
But fourth, rather than moving forward with that, what's being suggested is Mr. Coman will call up Mr. Kell and see whether maybe you can still get a deal done on the basis of a media release rather than an EU.
I don't think that does characterise what was happening. We were doing both in parallel. And again, I can't represent what the CBA representatives were thinking. From my perspective, the reason for that was that this issue of understanding the definition of general advice versus personal advice is an extremely difficult industry-wide issue. And, we felt that we had acted as best we could to get it right, although accepting that we hadn't got it right, and that getting proper resolution of these definitions for the industry was important, including the fact that BT had gone to court on the same matter.
The letter that had been sent suggesting the EU had been signed by Mr. Mullally.
Sorry, I don't know.
Let's go back to that. That's cba.0001.0478.0064. I'm sorry, Commissioner, I tender that email.
Email Shafir to Coman and others, 8 August 17, CBA 0010479138 as Exhibit 5.227. You're now going to CBA 001047800064.
Thank you, Commissioner. And if we go to page 3 of that document, so Mr. Mullally, who's the Senior Executive Leader for Financial Services Enforcement, has sent this letter offering the EU. Are you able to, you may not be able to explain it, but able to, as best you can, explain the strategy of trying to call the Deputy Chair about this issue to see whether he will override what Mr. Mullally has done?
I don't think it was. Well, again, for me, that wasn't how that was characterised. The discussions that I was involved with around why it was important to meet with Peter Kell was to raise with him our concerns that the industry would still have no clarity on what the definitions of general advice versus personal advice were, and that's what we were advocating for more guidance or more help or more assistance, or to start the advocacy kind of approach to the industry needing to understand these definitions.
Well, the premise for that is it, that a product like Essential Super could be sold by customer relations staff in the branch, is that right?
Yes,
And could be sold without those members of staff giving any personal advice to the customer.
that's what would be required. Yeah.
Just is far from apparent to me how that could possibly occur.
Yes, that's the issue, Commissioner.
Now, Mr. Coman did speak to Mr. Kell? Or you're not sure?
I think so. I'm not sure, but I think so.
So if we bring up CBA.002.1610.0161. We try CBA.0002.1610.0161. So this is the response you'll see from Mr. Coman on the 10th of August, saying, I've left a voicemail for Peter Kell, will revert with response.
Yes?
And we know, in fact, that the process ended up with an enforceable undertaking.
Yes?
So we can assume Mr. Kell didn't go with the idea of a media release?
I'm not even sure if that was what Matt discussed with him.
All right. I tender that document, Commissioner.
Emails of 8 and 10 of August 17 concerning ASIC Re-Essential Super, CBA 0002 1610 0161, Exhibit 5.228.
And then one of the ongoing matters of discussion was what was going on with ANZ.
I don't think that was discussed very often. We were aware that ANZ had similarly withdrawn its similar product from market, so we were aware of that.
You may or may not be aware of this. Can we bring up CBA.0002.2533.3421? This is a continuing on of the chain of emails, but it doesn't seem to be one that you're copied into.
Yeah, no, I am on this. Oh,
Oh, I'm sorry. Actually, you are on
Yeah.
the top one. So you see,
but not on the other one, no.
yes. So there's an email, an internal email, which says, "Do we have an update on ANZ's current position? You may recall they were willing to accept the EU, but only on the basis that they would not admit that personal advice had been provided, as they were concerned that this admission would expose them to ongoing liability. It would be useful to know whether they are still holding to this position." You see that in the middle of the page?
I see that.
And then there's then an email from Ms. Shafir to you and to two others saying, "Do you have any further intel on ANZ?"
Yes,
Do you know why Ms. Shafir would think that you had intel on ANZ?
because I obviously am the superannuation leader in CBA. So if ANZ had made announcements or had withdrawn whatever was happening with ANZ, I was the one likely to know.
If they'd
Plus
made an
through
announcement.
industry, yeah, or through industry associations, obviously I am likely to know people at ANZ. Yeah.
Was there some communication happening between ANZ and CBA as to what positions they were each respectively taking with ASIC?
There was certainly a lot of discussion around the issues I was talking about before around general advice and what the problem was, and we were both aware that we were negotiating enforceable undertakings.
Discussions between ANZ and CBA?
Not that I'm aware of. I mean, there was discussions, for example, at the FSC might be a place where everyone was talking about the problem to do with general advice and personal advice, and BT going to court and, you know, us looking at enforceable undertakings, we were withdrawing the product from market and so on.
The FSC is the Financial Services
Yeah.
Council.
I mean, that's just an example, obviously, in contact with each other in the industry.
Do you know...
I'm never aware of a formal discussion between ANZ and CBA, not to my knowledge.
Do you know how it was that Ms. Rava knew that ANZ were willing to accept the enforceable undertaking, but only on a particular basis?
No.
Okay. Presumably that information can only have come from ANZ.
I don't know. Presumably. Yes.
I tender that email, Commissioner.
Emails of October 17 between Shafir and others, draft EU received from ASIC, CBA 0002 2533 3421, Exhibit 5.229.
And then can we bring up CBA.0001.0478.0555? So this is another chain of internal emails from the end of October 2017. And you see at the bottom of the page, Ms. Shafir is emailing Mr. Coman and Mr. Sullivan, explaining that a view has been put to Mr. Mullally of ASIC that ASIC should wait until the Westpac proceedings are determined before taking CBA's matter any further.
Yes, that's an example of the sort of discussion that was going on, you know, as I was saying, between industry players as well. We were trying to understand to what extent the BT court case would inform these areas which were very grey.
And the suggestion from Ms. Shafir, this seems to be to Mr. Coman, is in that context, I don't think there is... Oh, I'm sorry, I should go back a step. You'll see that Ms. Shafir is communicating that the position from Mr. Mullally is that it was clear that this was not going to be acceptable.
Sorry.
You
Say it
see
again.
the second paragraph of the email at the bottom of the page. Angus and I raised with Tim Mullally the view that ASIC should wait until the Westpac
Yes.
proceedings are determined before taking our matter further.
Yes.
It was clear that this was not going to be acceptable.
Yes.
And then in this context, I don't think there is any great need for you to meet with Kel this Friday unless you would like to have a further go at pursuing this.
Yes.
And then Mr. Coman's response is, thanks, Larissa. I think we should keep trying. I don't think it will achieve much, but don't think I've got much to lose either.
Yes.
And then the responsive suggestion is, true, perhaps a conversation with the new commissioner who may have a different perspective.
Yes.
And now you're not on this chain of emails.
I'm not.
Were you aware that
Ye-
there were efforts being made by CBA to try to defer the enforceable undertaking until after the proceeding had been dealt with against Westpac?
I'm aware of us talking about that, and as I said to you again, that would be an example of where the industry would be talking to each other, saying the outcome of the BT court case could, depending which way it went, help resolve the broader issues for everyone. And so we were considering whether it, in our view, if we had that outcome from the court case, we'd have a better view of understanding of what had really gone right and wrong, because there was still a lot of confusion about that.
Now that was October of 2017. The enforceable undertakings from CBA and ANZ were ultimately given in July, at the end of July of 2018,
Yes.
a couple of weeks ago.
Yep.
Do you know what happened in the intervening 8 or 9 months?
I think it's it's just the normal course of negotiating the EUs. I'm not sure of the timeline here, what this date is versus when ASIC first. Yeah, I mean, you need to line those timelines up.
Tend to that email, Commissioner.
Emails between Shafir Coman and others 30 and 31 October 17 concerning a call from Peter Kell's office, CBA 0001 0478 0555, Exhibit 5.230.
I don't have any further questions for Ms. Elkins,
Thank you,
Commissioner.
Mr Hodge. Yes, Mr Finch.
Thank you, Commissioner. There's no re-examination.
Yes. Thank you. Ms Elkins, thank you very much. You may step down.
Commissioner, would it be convenient to take a 10-minute break now and then we'll start with Mr. Chun?
How are we travelling for time? Mr Hodge not well, I think.
I think I'm more optimistic than you are, Commissioner.
Exactly so, Mr Hodge, exactly so.
Always the case.
If I come back at, when, 10 to midday?
Yes, Commissioner.
Or quarter to midday was
Quarter to
what you were
midday.
about to say.
Yes.
Quarter to midday it is.
Thank you, Commissioner.
Thank you.